Good morning, everyone. Welcome to the Michigan Court of Appeals. This is the second day of case call for panel one of the court's June 2026 session. My name is Miriam Bazzi, and I'm joined here today by Judges Michelle Rick and Allie Greenleaf Maldonado. We understand that these cases are important to the litigants and counsel, and I want to assure you that they are important to us as well. We have been diligently working on these matters. We have had the benefit of your briefing, which has been very thorough, as well as the work of our research division and chamber staff. We are familiar with the relevant facts and pertinent law, and so we ask you to focus oral argument today on your most salient points, please. Why you should prevail and what is critical for us to understand. Finally, we are hearing matters involving sexual assault victims, personal protection orders, and children. Because these proceedings are recorded, we ask you to please use initials rather than the actual name of any victim, child, or other vulnerable individual in this case. And with that, one moment. With that, we look forward to hearing your arguments today. Beginning with item number 14, calling case or docket number 376557, Angela Baslak versus Darcy Lipsky. Okay. And who is appearing remote? Okay. Counselor, before you begin, I am going to be keeping time. How much time would you like reserved for rebuttal? Thank you. You may proceed.
Good morning, Your Honors. Nick Curcio on behalf of the plaintiff's appellates. Thank you, and may it please the court. There's an adage among lawyers that bad facts make bad law. We would contend that there's a corollary that bad arguments can make bad law as well. And we think that's what happened in this court's 2024 opinion in Wickman versus Norway Township, which we're seeking to have overturned here today. Or through it.
I was on that panel. Did you know that, counselor?
I did, Your Honor.
Okay.
I'm hoping to persuade you to reverse that decision.
You're very polite about it, so I take no offense.
As I'll discuss, we don't fault the panel for that decision. We think that the arguments that were presented to this court were not the right arguments. Specifically, the petitioner in that case was a pro se plaintiff, both at the trial court level and then to this court, and challenged the denial of the petitions on the grounds that he shouldn't have to substantially comply with the statute. As this court knows, the Supreme Court has expressly rejected that in other contexts, says that the election law requires strict compliance, not substantial compliance with the filling out correctly the petition form. We think that there are very strong arguments that the form itself doesn't require this in the first place, and that those weren't presented to this court. And it's not your fault and not your colleague's fault for not kind of doing the petitioner's work for him. That's not what we typically expect judges to do. But we think we have done that work today, both in here and in the trial court. And when you really look at the text, structure, and purpose of this statute, and the specific context of this form, we think it's very clear that it's not asking for a political jurisdiction. They know that phrase, city or township, is used in other places in the election law. We think the context here overrides that fact, and to any ordinary person who looks at this just assumes that, and it correctly assumes, in my view, that it's asking for your postal information.
I'm sympathetic with you in regards to the way the form looks. I think the way they filled it out is the way virtually any reasonable person is going to fill it out. However, in reading Judge Hood, who's now on the Supreme Court, his opinion that he wrote in that case, I mean, the statute says what it says, and he followed statutory construction, and our hands are tied. So what can we do here for you today?
So we obviously agree that this panel's hands are tied in terms of the ultimate result that it can reach, but the conflict panel provision does allow you to issue a published opinion saying that you would go a different way if you had the authority to do so on your own, and then a 7-judge panel conflict panel can be convened and potentially look at this in almost an en banc type of review. That's what we're urging this court to do. We do think that Judge Hood's opinion really didn't grapple with these issues. If you look closely at that opinion, it states that the principal argument on appeal is a substantial compliance versus strict compliance issue. It does state that you're supposed to put your political jurisdiction, but it doesn't really go into much analysis of why that's the case. So that's what we'd urge this court to do, is to look at as courts typically do, the text, structure, and purpose and history of this provision. And that's what I focused on in our brief and want to focus on here today.
Where is the ambiguity though? Because what you're suggesting, counsel, is that we ignore what the Wickman panel believed was, unambiguous language in the statute. And as you know, we don't delve into issues of policy or statutory construction when the legislature has spoken plainly. So where is the rub there?
But we think the ambiguity comes from both the word city and township can have broader meanings than just political jurisdiction. That's especially true of the word city. The word city, first off, we've cited dictionary definitions that it's a population center, essentially a large population center, and the word township, more frequently town, admittedly, but township can mean the same thing as town, which means basically a smaller population center. And in the specific context of mailing addresses, which we think is what this is getting at, and we think that for a reason. That's because it occurs on the exact same line as the phrase zip code, which is exclusively a mailing-related word, and it comes on a line immediately below a line asking for the street address and rural route. Those are all postage terms. If you look at DTE cited a number of other places in the election law where it uses the phrase city or township, and we agree with DTE that in those contexts that phrase means political jurisdiction, things like places where you're registered to vote and things like that. But in none of those sections does it use the term zip code, and none of those sections does it use the term rural route. And it's just clearly not talking about mailing as this statute is. And there's even an express reference to mailing later in the same section, which I'm going to get to when I get to my structural arguments. So we think that the context of the statute overrides kind of the way that the legislature generally uses those terms in the election law, and at least creates an ambiguity. I'd go so far as to say the context is so strong that's not even ambiguous. Everyone who looks at this statute, it's been in effect for quite a while. I think this Wickman interpretation came out of nowhere. It's not something that people have been raising prior. I'd be willing to bet this is a practice that's been in place for a very long time and unchallenged, just because it's the way people look at it, naturally read this form and this language. We've also cited in our brief, going to the meaning of the text, the plain meaning of the text, some Google searches, which I know sounds odd. It's not something you're probably normally permitted with, but it is a mode of interpretation that the Michigan Supreme Court has blessed in a case called People versus Harris, where you can look at kind of data about how terms are used in practice. And we think it's very relevant data here because the internet is filled with forms similar to this, both government forms and private forms that ask for mailing address information. And the most common way to do that is to have a line that asks for city, state, zip code. And in that context, city is what's referred to as a postal city. And the U.S. Postal Service itself uses the phrase postal city. There are also forms, including federal government forms, including the I-9 immigration form that every employee fills out when applying for employment, that asks for city or town, state, zip code. That's admittedly different from township, but if we think it's close enough to township, and that township is defined in some dictionaries as being interchangeable with town, that it's just the natural reader is going to look at that and assume it's asking for a mailing address, as all the plaintiffs here did, plaintiffs in Wickman did, and as the township clerks in both those cases initially did. People versus Harris And it's not Google searches there, it's a corpus linguistics database, but there's, language in there. The majority embrace this concept of looking to kind of data of how terms are used in context as being relevant to statutory interpretation.
Well, again, my starting point is the, lack of ambiguity. Let me suggest and ask you your impression. Unlike forms I fill out on Google or for Amazon or my food delivery service, which very clearly have to correlate to my residence, this particular matter deals specifically with the electorate. And would you agree, counsel, that in order to verify the proper standing of the signatories, knowing where they vote and referencing voter rolls would be most critical, because only registered voters sign petitions such as this, just like only registered voters sign candidate petitions so that people can qualify to get on the ballot. And might that distinction in your mind, or might that fact within your mind, how do you respond to that?
So I think I have several responses. The first is that the specific language that we're interpreting, that's not the case. A circulator can be from outside of the area where the petition is being circulated, it can even be from out of state. So that particular, the clerk doesn't need to check and doesn't need to necessarily know which jurisdiction they're in. Secondly, this same section we're interpreting, 544C4, this is going to my structural argument, specifically refers to certified mail to this address. So this idea that you'd be sending certified mail to an improper postage address just doesn't make sense. We don't think that's what the legislature could have been intending. And then thirdly, in the context that you're talking about, the verifying of signatures on the actual, the 10 lines that are provided above, there's actually a separate statute that deals with that and actually allows them to say their postage address. So it's almost the opposite. And that statute is 552A2. So we argued in the trial court that statute overrides.
Complete citation.
It's whatever the election law is, 168, I believe, and then 552A, little a, then parentheses 2. That specifically allows the signers to put their mailing address. And we argued in the trial court that overrides Rick Wickman. We got rejected on that, and I think probably rightfully so. It's pretty clearly talking about those 10 blanks and not about this one. But I think that's relevant to the purpose of the legislature, that the legislature itself didn't think that it was requiring that here, because it wouldn't make sense to require it here and not require it in that section where it actually is relevant, whether they live in the relevant voting jurisdiction. My understanding is, with the way the QVF file is set up, the qualified voter file, it's pretty easy to just take a mailing address and verify where it is within, whether it's within the district or not. So I think I've covered my textual arguments and my structural arguments. I'll just close on what I guess we've called purpose arguments. We do think that this interpretation has some really negative, I'd go so far to say absurd results that are going to cause problems in elections, not just in small townships, but potentially statewide elections. And the reason for that is, for one, this provision doesn't just apply to local zoning petitions. It applies to nominating petitions for statewide offices. It also applies to statewide referendum petitions. It basically applies to everything that requires signature gathering. And in preparing for this oral argument, I looked at materials for recent Board of Canvassers meetings. This is something that is being brought up in challenges at the Board of Canvassers. I think that's going to keep happening and ultimately going to affect potentially a very big election. And then a related point, there's just really significant questions of how you would apply this in certain contexts, particularly given that Michigan allows out-of-state circulators, and out-of-state circulators are pretty common in statewide elections. And a lot of states don't have townships, or they don't have townships that cover the entirety of the state.
They can just write none.
I don't know. I suppose, but then you really have a difficult mailing address to follow. If they were to write none in that blank and then provide their zip code, and I don't know. I think that could cause problems with the Secretary of State contacting them if they have none in that blank, because it's the only address provided on the form for the circulators. And under 544C4, that's the address that the Secretary of State is supposed to use to contact them. So possibly, but I think that's a pretty big difficulty that could arise. So unless the court has further questions, I'll reserve the balance of my time, but would ask that you find in favor of these arguments and open the door for a conflict panel to be convened. Thank you.
No further questions, Counselor?
Yes, thank you, judges. I represent the appellee, and the appellee literally kind of sits here in the middle as a dog without a fight in this. We just want to do what's right by the citizens, and that's what we initially attempted to do. After learning about the Wickman decision, which on its face appears to have been correctly decided based upon the statutory interpretation, we wanted to make sure that we just did everything procedurally correct. The lower court in this case followed the established procedure. The facts were undisputed. Just to bring up a few of the points that counsel brought up, this is truly an issue that should go back to the legislature if there truly is an issue of disenfranchising voters, which I think every level of the court system has now said, there is some risk of that with the interpretation that has to be made of the statute as it exists. But it's an unambiguous statute that raises the issue of strict compliance like the previous court had held. So Minden Township is just looking for an answer of did we do things the right way the first time? Or did we do things the right way after learning of the issuance of the Wickman decision and obviously the Supreme Court's idea that they would not take it up because it was rightly decided, and with the concurring opinion saying, again, what all the other levels of court have said in this matter, that it's a matter for the legislature. I am happy to answer any questions you may have on this matter.
All right, no questions. Any rebuttal? All right. Thank you very much, counselors. This matter has been submitted.
Thank you.
Calling item number 17, docket number 370564, J.S. Turner versus J&J Slavic Inc. Good morning, counselor.
Good morning, Your Honors. Mark Demarest for J. Turner.
Good morning. How much time would you like for rebuttal?
5 minutes, please, Your Honor.
You may proceed.
Yes, Your Honor. So I represent J. Turner, who is a 25% shareholder of a real estate development company. I realize that there are a lot of issues in this appeal, both with the appeal and the cross appeal, which have been briefed extensively. I want to focus on the remedy. So J. Turner invested, as Justice Young, the trial judge, found $425,000 into this company. The court also found that the defendants had engaged in minority shareholder oppression. That finding is well supported by the record. He also found that the defendants engaged in spoliation of evidence, which prevents the company from being valued. And there was no appeal of that finding of spoliation. So we have Mr. Turner, who in 1989 invested $425,000 into this company. And what the trial court essentially said was, we're going to rescind that transaction, and gave interest from the date of the original investment, but did not fully rescind the transaction because the court gave an amount of money that was based upon a determination of what the company supposedly was worth several years later. We believe that the appropriate remedy here, if it's a rescission type remedy, is to return to Mr. Turner his full investment of $425,000.
Now, the amount was based, I believe, on the value in 1991 when there was kind of this breaking up of this relationship. Is that correct? It wasn't as if it was just several years later, but that was the value when they began to, I guess they kind of parted ways, but they didn't do so officially, correct?
That is the date that they parted ways, but there was a specific finding from Justice Young, number 62, which says there is frankly no financial evidence of what the fair market value of the J&J assets were on December 31, 1991, or what happened to those events, or to those assets thereafter. So what we have is an undisputed finding on appeal that there was spoliation. We have a finding by the trial judge that it was not possible to value the assets in 1991, yet the amount of damages is based on, some determination what the assets were worth in 1991 when the trial judge says, we don't know what they were worth.
Well, what did the judge believe? What was the $25,000 then based on?
$25,000 was Mr. Turner's cash investment. So when he invested in the company originally, he wrote a check for $25,000 and he contributed the stock of another real estate development company that he owned. And there is a finding of fact that the parties agreed that the value of that stock in 1989 was $400,000. And then the trial court awarded interest back to 1989, but didn't, if it were not restitution, then restitution and to rescind, set aside the original transaction, the interest would have gone from a later date. So the decision of the trial court, I think, is logically inconsistent. Either we're rescinding the transaction as it was originally entered into, and have interest from that date and the original value of the investment, or if it's to be determined what the value was on December 31, 1991, based on the spoliation. The trial judge also said, we don't know what the company was worth in 1991. So my client shouldn't be penalized by the defendant's spoliation of evidence and their minority shareholder oppression. So we think that the appropriate remedy is to do the rescission based on the original investment. The other important point is attorney's fees.
Can I ask you a question?
Yes,
How
Your
do
Honor.
we review the judge's decision?
Pardon me?
How do we review the judge's decision? Do we review it for an abuse of discretion?
Well, I think as to anything that's based on fact or is an equitable decision, I think it is an abuse of discretion standard. If it's a legal issue, it's de novo. So I realize that there is a difficult burden for us to overcome considering the standard of review. However, when you take a step back and look at the decision, I don't see how one could say, without abusing discretion, to say, I've decided that I'm going to give Mr. Turner $25,000 back when the company value in 1991 couldn't be determined because of the defendant's actions. And that the fact that the court awarded interest back to 1989 indicates that what the court was trying to do was rescission, but only did it halfway. So we think Mr. Turner is entitled to get back his investment with interest. The other issue is attorney's fees. So originally, Justice Young, acting as the visiting trial judge, awarded us $200,000 in attorney's fees, which was much less than what we were asking for. This litigation has been going on since Mr. Garrett and I were much younger. Yeah, but the court then decided that, well, yeah, I know I told you you could have $200,000 in attorney's fees, but I don't have authority to do that. Respectfully, and this question, I think, is a question of law that's de novo, is there are two different issues. One is under MCL 450.1489, the minority shareholder oppression statute doesn't specifically address whether attorney's fees can be awarded as part of the court's equitable authority to fashion a remedy. I believe this is actually a question of first impression, and that we've cited case law that we believe that the court does have authority as part of fashioning a remedy under that statute to award attorney's fees. But even if that were not the case, there are other grounds, and one is the international outdoor case. There are two Court of Appeals docket numbers 359082 and 359811, which provide that the court may award attorney's fees in the event of fraudulent or unlawful conduct by a party. Fortunately, unfortunately, I'm now very familiar with that case because I'm representing International Outdoor and remand and arguing about, how much in attorney's fees they have to pay to the other side in that case. But International Outdoor case provides for award of attorney's fees when there's fraudulent or unlawful conduct, and we certainly have that here. We have minority shareholder oppression, which violated the statute. We have spoliation of evidence, which again, that there was a finding of fact that occurred, and there's no appeal of that. So that's binding at this point. So I think whether or not the court has authority under MCL 450.1489 to award attorney's fees specifically, there are other common law bases to award for attorney's fees, and we would ask the court to reverse that, not necessarily asking the court to change the amount, because I think that's already been decided. It was a question simply of, did the court have authority to award that, and Justice Young reconsidered his decision on that. He was looking at a different part of the Business Corporation Act when he awarded those fees, and then decided that he didn't have authority under that other part of the Business Corporation Act to award fees, but I think, missed a couple of other grounds for awarding fees. Then the last issue in terms of remedy is interest. Simple interest was awarded, but there's a lot of case law that supports compound interest. And also the parties in the documents, when Mr. Turner became shareholder, had agreed upon an IRS rate of interest, which is equal to 9.6%. And that was not, the trial court didn't follow that. And we believe that it would be more appropriate to award the interest rate that the parties agree upon and compound interest. There are a lot of other issues in the appeal, but I think that's, from my perspective, those are the key issues. I'd be happy to answer any questions that you may have for me. All right, thank you.
Further questions? Thank you very much.
How much time do we have left, Judge?
19 minutes.
Oh, I won't need that much. Thank you.
Morning, Your Honors. Please the court, William Garrett appearing for the defendants.
Morning.
Before I launch into the issues in this case, I would like to make two observations. Mr. Demarest and I have each suggested that there are errors in Justice Young's decisions. But in truth, he was placed in a very difficult situation. This was his first trial, we were told. And I think that Mark would agree with me that given the relative complexity of this case and the fact that he had it for only a couple of weeks before trial started, he really did a good job with most of the case. And two things that I will never forget about his behavior is that I don't believe I've ever been in a trial where a judge exuded and generated a more collegial atmosphere. And this was a difficult case, given the parties involved, but he was very collegial, and the fact that he would consider on the merits reconsideration motions, I think is evidence of just how thoughtful he was in what he did in this case. That doesn't mean that I withdraw the appellate arguments that I've made, but he was placed in a difficult situation. The other thing I would like to say in advance of talking about the issues is that my client wants to end this litigation in the worst way. I even offered to waive oral argument, and Mr. Demarest said his client wouldn't let him waive oral argument. When Justice Young's decision was finally rendered, I had in my trust account and offered to pay Turner the $80,000 or $90,000 amount for the stock in order to try to move this thing along. Mr. Demarest declined the offer. So we want this saga, which has gone on now for 30, I think more than 30 years, to end. One thing that the court said this morning, I think is particularly true. I don't believe that Mr. Demarest can meet the standard of abuse of discretion that he has to meet for each of his arguments other than the one that he didn't mention, which was his appeal of the directed verdict as to count 3. If he can't meet the abuse of discretion standard by showing that Justice Young's decisions were basically irrational outside the scope of reasonableness, then he's not entitled to any relief. In addition, I would urge upon you the fact that finding of Justice Young that there was spoliation implies, according to Mr. Demarest, that my client destroyed documents. There's no evidence that my client destroyed documents. There's no evidence that my client caused documents to be destroyed. The fact of the matter is that businesses don't keep their records forever, and records were destroyed in the ordinary course of the corporation's business. And consequently, we were not able to produce, after 2019, documents that existed in 1992. Mr. Demarest wants you to rescind. He wants to change the allegations in his pleadings. He wants to now rescind the purchase of the stock in 1989, claiming that the value of Turner's contributions to J&J were $425,000. Well, there was no action. There was no pleading at any point in time suggesting that the transaction in 1989 ought to be rescinded. All we have here, the claims are fairly simple against Ron Slavic. It's a shareholder oppression claim and a jury claim for breach of fiduciary duty. And I doubt that Mr. Demarest has ever seen a judge as tolerant as Justice Young was, giving him about an hour to try to explain why a directed verdict to count 3 wasn't in order. I've quoted some of the colloquy that lasted an hour between the judge and Mr. Demarest before Justice Young finally brought down the gavel and ended the frivolous count 3. I think I've established in my brief that there's no basis to impose Section 489 liability on J&J. This is a statutory cause of action. And as for Mr. Demarest's argument before you, that you should award attorney's fees, even though 49 does not call for the award of attorney's fees, I point out to you the fact that there are other sections of the Michigan Business Corporation Act that expressly allow for or require the award of attorney's fees, and the legislature did not put that language or similar language in section 49. So as a consequence, Mr. Demarest and Mr. Turner are not entitled, I think, under any circumstances, to attorney's fees for section 49 liability. I believe that there are ways that this trial could have been averted. I believe, for the reasons I've cited in the brief, that C8 summary disposition should have been granted as to section 49, because there was no pleading, in spite of the case law that I've cited, that requires pleading and proof of intent to substantially interfere with a shareholder's rights as a shareholder. There was never any pleading to that effect. Alternatively, summary disposition should have been granted on in essence, the same basis, because Ron Slavic filed an affidavit saying that he had no intent to substantially interfere with Turner's rights as a shareholder, and there was no contrary evidence. But C8 summary disposition and C10 summary disposition was denied to us by prior judges assigned to the case. I think the most important thing to realize is that the value, assuming for the sake of argument, that Turner's stock in J&J was worth $425,000 in 1989, the value of that stock depreciated drastically in the next 2 years, as I've laid out in my brief and as the record shows, and as Justice Young's findings show. The bottom dropped out of the market because of the savings and loan disaster, and other problems occurred with J&J's assets, as a consequence of which Mr. O'Keefe, who was the one witness in the case that Justice Young, whose testimony Justice Young truly valued, he was a CPA and the CFO of the company, he declined to exercise his option to acquire additional J&J shares and refused to join Mr. Turner in Mr. Turner's suits against Ron Slavic because he believed that the stock was worthless. And Mr. O'Keefe testified that in 2009, he calculated that it would take $45 million to be added to J&J for the common stock to be worth anything. And that assumes that a roughly $2 million debt to the preferred shareholder would be paid off, because common shareholders are not entitled to distributions until the preferred shareholder is paid. And there's no evidence that the preferred shareholder was paid his preferred dividends of $50,000 a year. And Ron Slavic, my client, was not the preferred shareholder. Rather, it was the estate of his deceased father. And Ron has a sister, so that can't be laid at Ron Slavic's feet. I think then we have the whole statute of limitations problem with regard to 49. Is there no statute of limitations applicable to those claims at all? Is it a 6-year statute, or is it a 2 or 3 year statute, depending on the circumstances? My position is it's a 2 or 3 year statute, and that because Turner knew everything, all of the supposed shortcomings of Ron Slavic as they occurred, then because he knew that he had the duty to bring suit within 2 years. He sued in August of 19. You go back 2 years, August of 17. What conduct of Ron Slavic occurred in that 2-year period that gives rise to Section 489 liability? And the answer is none. So I respectfully request that you affirm the decision of Justice Young in all respects, except that you reduce the amount that Ron Slavic has to pay for Mr. Turner's worthless common stock to a nominal amount. The concept that someone who is suing on a claim that covers a 2-year period, 2017 to 2019, the concept that the defendant in such a case has to pay 32 years of interest based upon a pure speculation that his stock was worth something, and specifically worth $25,000 in December of 91, I think is substantially incorrect. I don't have any further argument. If you have any questions, I'd be happy to try to answer them.
No questions. Thank you very much,
Thank
Counsel.
you.
I want to address a couple of issues that Mr. Garrett raised. This isn't simply a question of there's a 7-year retention period for records, and records are disposed of in the ordinary course. That's contrary to the facts and the findings of the trial judge. I'll read you one of the findings from the trial judge, number 100, from Justice Young. Why have defendants invested so extensively to withhold its financial records from Turner? I conclude that the most obvious answer is that the defendants have hidden the true value of defendants' assets so that Turner could not properly value his stock or recover proper compensation for his investment in J&J. Alternatively, this course of conduct might be an attempt to insulate Ron Slavic from his breaches of duties to the only non-family shareholder. This isn't some case of innocent, record destruction due to some record retention policy. It's the trial judge found this is a conscious effort to keep records away from Mr. Turner, as Justice Young said in the finding, the only non-family shareholder in this company. And so we have a few points in time that are relevant. 1989, we know that Turner invested $425,000. That was a finding of fact at the trial. In 1991, there was testimony from a witness who was previously involved in the company as to what he thought the value was. But again, Justice Young made a finding that there's no financial evidence to show what the fair market value was on December 31, 1991. Then let's look at what happened after 1991, because there was an agreement that Turner's stock would be redeemed at the time his employment ended at the end of 1991. Right, actually it was early 92, but valued as of 91. That never occurred. And in a prior appeal, this court determined that because the redemption did not occur, Turner remained a shareholder. That was a 2014 decision of this court. At the time that Turner left the company, J&J Slavic had investments in 40 different real estate projects. Right, either they owned the land or they had an interest in the entity that owned the land. And these were real estate projects that were at different stages. Right? After the time he left the company, Turner had no access to information, no involvement. And so what happened to those 40 different real estate investments? The most recent financial statement that Turner received was in 2015, which was after we finally got the ruling that he was a shareholder. We said, okay, tell us what the assets are. They gave us in 2015 a financial statement that was backdated. Well, I wouldn't say it was backdated. It was dated as of 2009. So we received it in 2015, and it says, here's what the company has in assets in 2009, which is about 2 decades after Turner left the company. At that point, the financial statement showed that there were over $13 million in assets that the company had, and that these real estate project investments had now become, those assets had been liquidated and had been converted into assets like cash, securities, promissory notes, condos in Colorado that Ron Slavik could use for skiing, transportation equipment, which is luxury vehicles and motorcycles that Ron Slavik rode and used for his personal use. Turner didn't get the benefit of any of that. And we don't know what happened to those assets after 2015, what happened to those marketable securities, what happened to the motorcycles, what happened to the marketable securities. And that's because of the spoliation of evidence. So even though there is, a high standard to overcome here, I think if you look at the whole record, and I recognize that Justice Young wrote a very lengthy, very detailed opinion. He's obviously a smart man. I agree with Mr. Garrett that he did a good job of handling the trial, but I think he missed the boat on some of the conclusions he reached in his opinion, that if we don't know what the value of the assets was in 1991, then the only logical remedy, in my view, is to rescind the transaction, which is certainly something we asked for in the pleadings, and it was, I think it's, it's supported by law as to, Mr. Turner was shut out of this company. All of the benefits after 1991 went to the Slavik family. They purposely kept him out of the company. They purposely excluded him. They didn't redeem his stock. And the only logical remedy is let's just rescind the transaction, give him his money back with interest and attorney's fees. So that's what we're asking the court to do. I'd be happy to answer any other questions. Everything else I think is covered by our brief.
Thank you.
Right.
Exceedingly brief.
We have cross appeal.
Yes, cross appeals.
Yeah.
So he gets.
Be exceedingly brief. If Turner wants or wanted to rescind the 89 transaction, he should have brought suit within 6 years by 1994. If Turner wanted to sue to make J&J redeem his stock pursuant to the 89 agreement, that suit had to be brought within 6 years after Turner left the company, which was January 92. So that suit, that bird flew out the nest in 1989. Mr. Demarest and his client cannot prove that Justice Young abused his discretion. And he's apparently all but abandoned his argument that there shouldn't have been a directed verdict with regard to count 3. So I ask that you not give Turner any relief, because all it will do is continue to make this case boil more and more. And I can't be around for another trial. And I'm not sure Mr. Demarest can either. Thank you.
Thank you very much. Thank you both for, I know this was a very long case, 3 decades, 3 suits. And so we appreciate the very thorough briefing from both of you. Thank you. This matter has been submitted. Calling item number 18-377-457, Melvin Meeks versus Kayla Harbin. This matter is here. Oh, Doc. Right. I'm going to say this matter is here, going back to my trial court thing. But anyway, this matter is here for oral arguments. How much time would you like for rebuttal, Counselor?
5 minutes, fine.
5 minutes.
Your Honors, as you probably have seen from our brief, this involves.
You can start with your appearance, please.
Wendell Davis on behalf of the appellate Melvin Meeks. As this court has probably have read in our brief, Melvin Meeks was standing on a corner in the city of Pontiac waiting to go to a job application. And at that time, he looked up and he, within split seconds, saw a box truck coming and looked like it was being chased, and then suddenly strikes him in the front. It, of course, propels him to the ground where he's had multiple injuries over his body. Now, this case was brought against the defendant employer, who was Buselli Sales and Antonio Buselli. It was also brought against the driver for those two defendants, Mr. Teasley, Lamar Teasley. And it was based upon Section 3135 of the Act, respondent superior, vicarious liability, and also the Michigan Owner Civil Liability Act. But I'll first start with the application of the court's decision, which actually determined and was the basis for dismissing all of our claims. The court looked at the City of Pontiac vehicle unattended ordinance, and for some illogical reason felt that it was limited to only areas where there was a highway and public roads. When we look at, and I'm sure the court has looked at the provisions of this ordinance and sees that there is no language within that ordinance that would limit its application, so long as the circumstances giving rise to violating that ordinance may have caused a particular incident in question. The ordinance requires that one must lock his car, must take the keys out of the ignition, make sure that the car is not unattended. In this case, it is clear from the facts that co-defendant Teasley, during the course and scope of his employment for Buselli Sales and Anthony Buselli, violated all the provisions found in the Pontiac City unattended vehicle ordinance. He left the car unlocked. He had it running. Nobody was in the car. And during this course of employment, he had previously stopped at a store and purchased goods and went to his house. And that's where the vehicle was stolen. It was stolen by someone that would not have taken this car had Mr. Teasley not violated the provisions of the Pontiac City. The trial court determined that this ordinance only applied not in residential parking lots, which is where the evidence shows that Mr. Teasley parked this vehicle when he went into his residence, which is used by the public and used for the purpose of vehicular operation. She, for some ungodly reason, limited the application strictly to highways and to public roads.
But was she believed that and when that language on that last sentence
Yeah,
meant
but
it
that
had it
just
to be a
deals with
highway?
I think that might have turned her around, but that's not what the language meant. It's just the location of making sure that the provisions in that ordinance are complied to if you're on a perceptible grade.
Counsel,
It doesn't.
counsel, I appreciate your advocacy for your client, but please don't speak over Justice Watson or Judge
Oh, I'm
Watson.
most sorry. I didn't mean to.
It's-
Not
it-
at all.
Okay, counsel. She, yes, she interpreted and when to mean that that was also a condition that was necessary. However, it appears that that might be a condition when a certain circumstance additionally exists, then that would apply. Is that your argument essentially?
In essence, the provisions and conduct that establish negligence under that ordinance was in addition to, and it has to be complied with someone that might be on a perceptible road. And it just requires that they then turn the brake and set the brake and make sure the tires are turned to the curb. But nowhere in the provisions of that ordinance does it say that it applies strictly to highways and public roads. The reason for this, the ordinance is to make sure those conditions of conduct are not violated anywhere where a car is allowed, where someone is allowed to operate a vehicle. And in this particular case, where this vehicle was parked, was in a residential parking lot where vehicles, again, come in and out and pedestrians are present. So the court making that decision then dismissed all our claims, saying that there was no negligence. Didn't look into the claim of vicarious liability, respondent superior, section 3135, or the Civil Liability Act with respect to owners. And in this case, the Civil Liability Act, as the court knows, against owners, imputes negligence against the owner for having given consent and knowledge to allow a vehicle to be used that he owns, that subsequently the user then uses negligently and causes harm to another. It imputes negligence to the owner.
May I ask a question? Actually, it's three parts. So with respect to the owner liability, respondeat superior, et cetera, the question goes to development of facts and whether that would support your cause of action vis-a-vis the owner. I couldn't tell from the record whether Teasley did or did not have a valid driver's license, whether the employer was aware of that, and whether the employer definitively the fact was definitively established that there was consent by the employer for employees to do personal jobs during the course of employment. So those were my three areas that I was curious about, and if you don't mind responding.
I think it was presumed that Mr. Teasley had a valid driver's license. I think it was presumed that Antonio Buselli would have checked to make sure before he allowed his truck to be used by someone like Mr. Teasley, an employee like Mr. Teasley, that he had a valid driver's license to operate his vehicles on public roads. But with respect to the concern that Mr. Teasley meets the criteria according to the Michigan Economic Reality Test, that he was an employee for Buselli Sales. He was operating in the course and scope of his employment. There's no way that permission was terminated because he decided to go to his house. His own testimony said, I don't believe I violated anything. I was never told by my employer that I couldn't go to my house while I'm doing my duties for the employer at that time. And of course, the case of Robert V. Posey that I supplied in our brief indicates that permission is not cut off if he fails to quite obey all the contents of the permissive use.
Would it make a difference then, counsel, if definitively the employer did not give permission? Then you would agree that would be outside the scope of employment and respondeat superior and owner
That is true.
liability, right?
Yes,
Okay.
yes.
So your position is because no one said he didn't have permission, that logically what follows is that at least he had implicit permission. And that is how you get to owner liability and respondeat superior.
Yes, sure.
Okay, thank you.
There are a couple other points that the appellees have raised on appeal here. One is that the Civil Liability Act, Owner Civil Liability Act doesn't apply because the owner in this case didn't give permission to the thief to drive the vehicle. I think that is so out of focus and out of touch with the facts in this case that it really doesn't require too much argument. No one would sit up and give a thief permission to take the vehicle. And the case that they used, I believe it's Graham versus Natras, that the permission was issued was not, weren't granted to the plaintiff's argument because it was just so illogical. In this case, it was clear that there was a permission granted. It's clear that the defendants wanted and had knowledge of that Mr. Teasley was using their vehicle on the day in question to actually fulfill his employment duties for the defendants at that time. And that really takes us to the point that negligence for the conduct of Mr. Teasley can be imputed, not just from the Civil Liabilities Owners Act, but also from the context of respondent superior and vicarious liability, because in those particular legal doctrines, the conduct in Mr. Teasley is considered the same conduct as the employer if he commits negligence. And in this case, I think it's very clear that there was permission. That permission was never terminated, legally terminated at any point in time, and that there is a clear violation of the City of Pontiac ordinance to present negligence that we find in our case of Davis versus Thornton. That case, Supreme Court case, clearly said that if there is evidence that negligence occurred because someone violated the unintended motor vehicle ordinance, then negligence is apparent. And I think from the facts, a trier of fact could easily find that Mr. Teasley, imputing negligence, also the other co-defendants, Buscelli Sales and Antonio Buscelli, were negligent because they violated the provisions of the Pontiac unattended motorist ordinance, and therefore should be held accountable. And we're asking this court to set aside the decision of granting this C-10 motion and to allow us to go to trial. Thank you.
Very much. Any other questions?
I'm sorry. Any questions?
Oh, no.
Okay.
Good morning, and may it please the court. My name is Trent Collier from the law firm Collins, Einhorn Farrell, and I represent Mr. Teasley, Mr. Buzelli, and Buzelli Sales. I'm not going to rehash my brief. I want to address 2 points, respond to the plaintiff, and answer any questions this panel might have. So the 2 points I want to address. Sometimes when you come back to a case a year after you've briefed it, you see things that you didn't see the first time. So I think there's a back and forth in the briefing and in the lower court about whether it was called a driveway or a parking lot. And I think actually the right way to characterize it is the way Mr. Davis did, that it was a residential parking lot. When you look at page 67 of Mr. Teasley's deposition, he talks about how this parking lot was for certain apartment units. And that means it's not a public parking lot. It's a private parking lot for housing. There's no evidence in the record that this property is generally open to the public. It's like any other apartment building. It's a private setting.
Are visitors excluded from parking if they don't have residence at the parking?
That's not in the record.
Okay.
Yeah.
So we don't know definitively then that the public can't park there.
By the same token, we don't know that the public can park there. There's no evidence on that point. The other point I wanted to raise, so Terry versus City of Detroit is a very important case for our position. There was an unpublished case that said that part of Terry on an issue of law that's not relevant to our arguments might have been overruled because it relied on an overruled case. So I just wanted the court to be aware. The unpublished decision is Hardman versus City of Detroit. I don't think it affects our case, but I thought the court should know. So turning to the issues, the problem with the ordinance. So let's say, for argument's sake, that the ordinance was violated. The problem is there's no duty. And this court's case law has been very clear, like in the Ward case cited in our brief, that unless you have a duty, the violation of an ordinance doesn't matter. And there is no relationship between these parties to create the kind of duty that would make the ordinance matter.
Doesn't the law say that violation of an ordinance is negligence per se?
That's breach. It doesn't go to duty. So unless you have a duty owed to that party, you don't get to the question of what is the standard of care and was it breached? That's where the ordinance comes in. So, you know, I obey driving ordinances going home. But I'm not doing that for the benefit of somebody I've never met. I'm doing it for the benefit of drivers that I see that because they're in close relationship with me. But again, the Ward case cited in our brief says, unless there's a duty, the ordinance doesn't matter. On the issue of the ordinance, 114243, there's no way to comply with that ordinance unless you are on a highway or a curb. If you just look at the plain text, it's like saying, when you get to the last line, you know, there's the only way you can comply with that line is if you were actually on a highway or a curb, and that applies to everything that precedes it.
Counsel, sorry to interrupt you,
No,
but
go.
I want to look at the Ward case again. Can you please, do you have a citation for me?
Yes. Sorry, just 1 second. No, it's okay. I see my iPad skills.
I've got to remember to speak into the mic.
I'm sorry, Your Honor. I'm not pulling up that site right now.
I'll write it down and look for it later. That's okay.
Yeah,
I thought if you had it at your fingertips.
yeah, I'm sorry. I just don't have the full site at my fingertips, but
That's
I
okay,
believe it
that's-
is cited in our.
I'm sure it was.
Okay.
I'm sure it was. I
Oh,
do
wait.
remember something about it, but I wanted to take another look.
Okay. So anyway, our position on the ordinance is that it only works is if you're actually on a curb or a highway. There was some discussion about whether the act of leaving the keys in the truck is what caused the harm, and the act of leaving the keys in the truck could give rise to vicarious liability or respondeat superior. I think Terry versus City of Detroit forecloses that argument because it says that there's no duty not to leave your keys in the car. So this court has held that that's not negligence, because the link between leaving your keys in the car and criminal action is so attenuated that you cannot you cannot create a duty out of that. That's also the case of Latham versus National Car Rental cited in our brief. On the issue of permission through the owner's liability statute, there's no evidence that Buzelli Sales gave permission for Mr. Teasley to go to his home. But the more important point is there's no evidence that Buzelli Sales gave permission to Ms. Harbin to steal the truck. That is what caused the harm. And unless Buzelli Sales and Mr. Teasley and Mr. Buzelli authorized that, there's no basis for respondeat superior or vicarious liability. Again, this court, and we've cited the cases in our brief, has held that theft is not foreseeable. We don't have a duty to prevent theft because it's not a rational act. It may be foreseeable in the abstract, but because it is such a breach of our ordinary lives that this court has held that you can't be responsible for other parties' theft.
Well, there is some line of cases tied to these ordinances that are designed to make it so that there is there's a legislation that acknowledges that there's inherent risk to leaving your car on and open, just kind of inviting theft and some liability attached. Can you address those for me, please?
Sure. I'm sorry, I'm not familiar with the exact legislation that you're talking
Just
about.
the ordinances that prohibit.
Oh, this,
you-
this ordinance.
Well, this one, there's a couple, like there's other ordinances that do this in other places. And, there's some, I'm trying to remember because we read a lot of stuff, but there was some legislative history to one of them that like talked about like the purpose of them, to like prevent theft, of vehicles. I don't recall, I'd have to go back and look again if it was directly, towards this, I don't think it was actually towards this particular ordinance, but generally there is a policy reason not to leave your car, someplace running with the keys in it. Can you address like whether or not that is something that is at issue here?
So I would say that that policy was foreclosed by this court in Terry versus City of Detroit, where the court said you're not required to hide your keys. And the other issue is if the legislature or, a city have enacted an ordinance that goes to this issue, that only goes to breach, negligence. It doesn't create a duty. And that's how this court has treated it. Duty is a question of law. And that's, one of the key reasons why, the plaintiff's key case is Davis. And the court cannot follow Davis because it treats duty as a question of fact. And for at least 20 years, the Supreme Court and this court have held that duty is a question of law. Davis is no longer a valid case, from our perspective. Those were the points I wanted to cover. I'm happy to answer any other questions.
So I thought, so Judge Rick's question is making me think. So
Okay.
I want you just to be very transparent because I think I was definitely leaning a particular way, but I am interested in hearing your response to Judge Rick's question. And I know you disagree with the how she teed it up. That's clear. But if I agree with how she teed it up, respond to her question about whether or not it's relevant that whether or not there was permission for the driver to use the vehicle for personal use.
Oh, for Mr. Teasley to use it for personal use. I don't think there's evidence in the record that he could, and I don't think there's evidence in the record that he couldn't. I think on both those points, I think it just wasn't explored below. But these issues like, I think Judge Rick, you asked about whether he had a driver's license and what was his employment record and so on.
Not his employment record, but whether the employer knew that he had his license was valid or was invalid. There was something in one of the transcripts that seemed ambiguous about that.
Yeah, I think my response on that issue is that the plaintiff never raised these issues as a basis to impose liability. And so with that argument not preserved, I don't think it can go to the plaintiff's benefit. I'm not sure I answered your.
No, that's
Okay.
that's a fair answer.
No further?
I have a question for
Okay.
you. I'm trying to understand where you're getting that this has to be a public road or highway beyond that last sentence where it indicates, and when standing upon any perceptible grade without effectively setting the brake thereon and turning the front wheels to the curb or side of the highway. Which it appears to me does not limit everything preceding that to a public highway, but merely if in this circumstance, then you would park it this particular way. But where else are you getting that this ordinance applies to a public road or highway?
It comes from the fact that there's no vehicle that this will apply to that's not on a curb or the highway, because it doesn't separate that out. It's only referring to, I mean, there's no periods in this paragraph. It's all part of the same paragraph, and it's all describing cars that are on the curb or the side of the highway,
Well, it
as I
says,
understand.
no person driving or in charge of a motor vehicle shall permit it to stand unattended. And when I look at stand, it says standing means any stopping of a vehicle, whether occupied or not. It doesn't limit it to a public road or highway. I mean, so I see how you're reading it, but I'm just looking, if I'm not reading it the way you're reading it, is there anything else that limits it to a public road or highway?
Let me give it one more shot. I'm not sure I've explained it well. So it says no person driving or in charge of a motor vehicle shall permit it to stand unattended and the engine is locked and removing the key, and when standing on a perceptible grade, turning the front wheels to the curb or the side of the highway. This only, because of that last part, it only applies to vehicles that are actually on the curb or the side of the highway. It's like if I'm trying to think of an example, like if there is an ordinance that applied to Michigan students who lived in Bursley, and it referenced Bursley Hall at the end, but Michigan students at the beginning, they have to be a University of Michigan student if it applies. Even though Bursley Hall is mentioned in the end, that's not a helpful illustration, I could tell. All right, so bottom line for me is, can we read this ordinance and find a way for it to apply to a car that's not on a curb or a highway? I don't think we can. I don't think that the plain text of this applies to anything that's not on a curb or highway.
Questions? Thank you very much.
Thank you.
Rebuttal?
First of all, the appellee contends that there's no duty. The duty is in the provisions of the ordinance itself, that we must obey as in driving a vehicle. And of course, Mr. Teasley did not obey. The case of Terry versus City of Detroit is not applicable here because there was only one contact issue. The keys were left in the ignition. In this case, not only were the keys left in the ignition, car was running, unlocked, nobody was in the car. You have much more context to establish a condition that can threaten society and harm someone innocently with somebody taking a vehicle under the circumstances of this case. So there is a duty. There was a violation of that duty. There is a distinction of the cases that appellee raises here from the facts in this case that make them irrelevant in terms of making a decision of whether this ordinance applies as a means of negligence against the defendants. Therefore, I'm asking this court to reverse the decision by the trial court because the trial court overreached, in her mind, came up with definitions of a public road and highway that are clearly not there in the ordinance. If it was, they would have said so, just like they did with an ordinance that we mentioned in our brief, where they mentioned it applies to public highways and public roads, which is having an open liquor package in the front seat. They could have easily done it for this ordinance, and they didn't because they wanted it everywhere. They knew that the danger was foreseeable everywhere when somebody uses a vehicle with the keys in the ignition, running, nobody in the car, and unlocked. So I think the just conclusion in this case, in all fairness to the facts, is that the decision to grant C10 summary disposition under a C10 motion be reversed and allow us to go to trial and have the issues discussed here. Thank you.
Thank you very much, Counselor. All right, this matter will be submitted. Turning to item number 19, docket number 374881, Gayla Ruth Stanley versus Farmers Insurance Exchange. We have oral argument for Ms. Parker. Is she on? Remote, yes. All right, Counselor, can you hear us?
I can hear you just fine. Can you hear me okay?
Yes. How much time would you like for rebuttal?
5 minutes, please.
5 minutes. All right, if you can place your appearance on the record and begin.
Certainly. Elizabeth Parker, appearing on behalf of the appellant. There are really two issues before the court, a sort of a threshold issue of whether this court even has jurisdiction to review this matter. And then secondly, whether the trial court erred in dismissing appellant's claim for medical treatment, where she executed a pretty standard consent permitting the hospital to obtain payment from her insurance company. Addressing the first issue, the stipulated order of dismissal in favor of arbitration doesn't flow from a release of all claims, but rather refers the remaining claim, to a different forum. And I think in that regard, the unpublished rulings relied on by farmers are distinguishable. But more importantly, this court really not need to reach that issue because this court could treat this matter as if on leave granted and still reach the merits. And I think it's significant that the jurisdictional challenge wasn't raised by motion before briefing or even questioned by the court's own internal jurisdictional review. The most recent cases addressing this jurisdictional issues like this, such as Jaber, are fairly recent. That Jaber opinion is 2024. And they reflect a resolution of a previously unsettled area of law. And so I would ask this panel, if it does believe that jurisdiction of right is lacking, that jurisdiction by leave be afforded. As to the second issue, I am satisfied to rely on the briefing unless the panel has any questions.
All right, no questions. Thank you very much.
Thank you, Your Honors.
Good morning, Your Honors. Rick Szymanski for Defendant Farmers. We, of course, respectfully disagree with plaintiff's position regarding this court's jurisdiction to hear this. As laid out in our brief, plaintiff unequivocally entered into a stipulated order of dismissal with prejudice of all claims so that the parties could arbitrate because that's what they agreed to do. There was no provision in that reserved any appeal rights. And I think the case law that was cited by us and that has come out recently is very clear that where there is a stipulated order of dismissal between two parties and two parties only, nobody is aggrieved because that stipulated order of dismissal is treated as a contract that they agreed to enter into knowingly. And so they did so knowing that we were going to go to arbitration and that is how this matter was going to be settled. It was quite our surprise when this appeal was filed afterwards because that's what we had all agreed to. I would just point out that there was a recent unpublished case which just came out a few days ago. I've discussed this with plaintiff, and that is the case of Issue v. Farm Bureau, docket number 370759. That addressed the recent
759.
Yes, Your Honor, 370759. That directly addressed a case that has practically the exact same fact pattern as this in light of Jabber 2. Of course, with Jabber 2, the court found that there was jurisdiction to hear the appeal, but that dealt with an entirely different set of factual circumstances where you had three parties. One party had been dismissed by summary disposition early on in the case, and at the end, the last two parties entered into a stipulated order of dismissal, after which the plaintiff sought to appeal the first party that was dismissed. And I think the court correctly said that yes, the party that was dismissed initially was not a party to that stipulated order of dismissal. They weren't a party to that contract, and so they could hear the appeal. The Issue v. Farm Bureau case involved a case that was similar to this, where we only had two parties. They entered into a stipulated order of dismissal, and after that, the plaintiff attempted to seek appeal as to some UIN claims that had been dismissed on summary disposition earlier. The Court of Appeals in that case, I think, correctly said the Court of Appeals does not have jurisdiction to hear that. The parties were aware of the contract they entered into. You didn't reserve any appeal rights. And I think that we have that exact same case here. So respectfully, I don't think that this court has jurisdiction to hear this appeal. I would just turn very, very briefly to the issues of whether or not plaintiff is the real party at issue, real party at interest in this case. And under the C-Spine case, I think it's pretty clear that there were two ways highlighted in there where a party who had assigned their rights to benefits may still be the real party at interest. One of those ways is by revocation or rescission. And in this case, there has been no revocation, no rescission of the assignment as to McLaren Hospital. The other way is that if the assignment includes a provision allowing that party to litigate those claims. And again, in this case, we do not have that. So I respectfully submit that plaintiff is not the real party at interest with regards to the McLaren Hospital claims, and their appeal should be denied.
No question.
All right, thank you very much, Counselor. Any rebuttal?
Thank you, Your Honor. Just briefly, I really can't speak to the surprise that was felt when the claim of appeal was filed because the arbitration agreement isn't in the record. And so we don't really know what those terms said. But turning to the issue versus Farm Bureau unpublished case, I would again point out that it is unpublished, number one. And secondly, the court may review this case as if on leave granted if there are jurisdictional defects that it believes prohibit review as of right. Excuse me. Turning to the second issue again, just briefly, under C-Spine, I believe it's been conceded that the assignment in this case did not transfer any rights to litigate the amount owing. And so in that regard, I would argue that the trial court, who didn't have the benefit of the C-Spine ruling at that time, couldn't make the evaluation in that twofold manner. And so I would ask that this matter be remanded to the trial court with directions to consider the assignment under the scope of C-Spine. Thank you.
Thank you very much, Counselor. All right, this matter has been submitted. Turning to item number 20, docket number 370851, Paragon 28 Inc. versus John Vuck.
Maybe it's just me, but it seems we've had a lot of hotly contested litigations, this case call.
That we have. All right, Counselor, how much time would you like for rebuttal?
3 minutes, please.
All right, you may proceed.
Thank you. May it please the court, I'm Jonathan Frank and I represent Patriot Medicals and Mr. Buck. I know the court's read everything. I just want to put it in a little bit of perspective. So Patriot Medicals is a sales rep based in Maine, and they handle medical devices and equipment in the Northeast. So Mr. Buck is the one who runs the show basically, and he'd run the show pretty successfully through the years leading up to this lawsuit. And just, we should keep in mind that this is the COVID era. So he's selling medical equipment into orthopedic surgeons who, in theory, need to be performing surgery in order to generate money. And so during 2020, sales are good. 21, the year this happened, sales start taking off because people are coming back into the operating room. So the context of this is that he's basically broken open the Northeast territory. If you look at finding number 4 from the lower court, which is, I think, one of the most significant parts of the case, the lower court identifies a very steep trend upward where Patriot Medicals is selling quite a bit more equipment. It's pretty incredible jump from 40,000 to 800,000 to 1.7 million. That's 2020, and then we're in 2021. So the context of this is Patriot Medicals is doing its job. Fantastic returns for Paragon 28. There's some kind of beef apparently with people within Paragon 28 and Mr. Buck. And in the middle of 2021, they decide, well, we're going to get rid of this guy. Turns out there's no evidence in the trial record to support that decision. So Judge Allen decided, properly so, that the termination, which happened in August of 21, was not proper under the annual contract that Patriot had to run through December. So the termination is in August. Judge Allen says, no basis for that.
So help me out with the record a little bit, because it was a little muddy, right? You had his initial decision about that issue was that there was a breach of contract, right? Am I remembering that correctly? And then later, so then he's like going forward on damages. And then when he gets, this is supposed to be like I guess a trial on damages here. And at the end of it, he's like, is he reversing himself there when he's like, well, no, there is no breach of contract now? How did you take that? Were you actually counsel?
Yes, I
Bob?
was.
Okay.
So there was ongoing conversation with Judge Allen as we were preparing, and the pretrial orders that Judge Allen asked the lawyers to present contain the issues that each side anticipates presenting at the trial. And we included all these issues with a notation in our document that under MCR 2.604A, as well as case law, a judge has discretion to make a final decision on a case that goes to a trial, even if he had already made a decision in summary disposition and might change his mind. He's allowed to.
Okay, so that's your view as to what occurred in the second half, correct?
Yes, for sure.
Okay, that's the clarification one.
Yes, and there's not really an argument that procedurally Judge Allen did anything wrong by doing that. We put in our brief the explanation. There wasn't a response to that. It's pretty well set that until there's a final decision, the judge controls the courtroom and can do whatever the judge wants, even if it means changing their mind. Even if there wasn't a motion to reconsider on the first motion, it doesn't matter. The judge has the power, so he used the power. So we know from finding number 4 that there was this upward trend. Finding number 4 also says that for the end of the year of 21, the period where Mr. Buck had been fired, there was sales that would have continued to grow through December. Judge Allen quantifies the number in finding number 4. We know he found that in the months post firing, there was roughly $1.5 million still that would have been sold had Patriot been able to finish off its year. Finding number 4 is not disputed. That's the underlying fact that we know. Our position is pretty simple, that by looking at the damage figure and coming to a $4,000 figure, Judge Allen didn't really reconcile the two things he found earlier, which is that there was a firing in August without a basis. The contract ran through December. Sales were going to be high for those last 4 months, and there was a 30% commission that should be earned. If that's all true, he can't mathematically get to a $4,000 damage figure. That was a really little slice of the money that was owed. The first issue is that, and I'm going to use round numbers, according to the briefing that you have, we already have a concession that the 4,000 figure should have been 84,000. The reason it's 84,000 is because the month of September showed some money, and Judge Allen didn't consider that when he got to his 4,000. So that's number 1. Number 2, Judge Allen deducted monies paid to subcontractors, and there's no response in opposition brief to my argument that that was improper. It's conceded. There shouldn't have been a subtraction for subcontractors. Who are these people? There were 4 people that were out in the field in the Northeast working for my client, Patriot Medicals. They were poached, all 4, by Paragon 28. So when they fired Mr. Buck's company, they still had his staff. Those people apparently said, hey, we should get paid for some of the work we did for Mr. Buck. And according to the trial evidence, Paragon 28 paid these 4 people. It's in the document, it's in the testimony. So they did a favor, apparently, for the 4 people that they poached and paid them. Michigan law that we've cited in a sales rep case is that you're not supposed to make a deduction from the manufacturer debt to the sales rep because the sales rep may have some internal costs that the manufacturer decides to jump in and pay direct. Can't do that. You have to pay the sales rep what the sales rep is owed. That's the law of Michigan, and we cited it. It wasn't responded to. So because of that, the math of the damage has to be at least $84,000. That's the starting point. that takes us through the problem, which is the bigger money problem, which is what happens for September, October, November, and December. Because the contract is still in place, it was wrongfully terminated. That's what Judge Allen found. And it's a huge last 4 months, according to finding number 4. It's a math equation. There's only 2 numbers that go into it. What is the sales volume and what is the commission rate? I'll start with the easy one. The commission rate is 30%. We argued that it should be 30. There's no response in the briefing. It's 30. That's his commission rate, 30%. What's the first number? Roughly $1.6 million. That's finding number 4. That's $480,000 that Patriot Medical would have earned in commissions had it been allowed to finish up the contract for September, October, November, December. It's just math. There's no disagreement about that in the briefing. The only argument in the briefing is that there was a mistake about the termination by the lower court, but there's no evidence that the lower court made that mistake. The lower court said there's a bad termination. But there's no argument in the briefing that says the math is wrong. There's no argument in the briefing that says the 30% is too high, and there's no argument in the briefing that says the 1.6 million is too high. So if those numbers are accurate, the only conclusion is that for some reason, when Judge Allen got to the very last line of his findings of fact, for whatever reason, he just didn't finish the job to award the damages that were supposed to be awarded through the last 4 months of the year. So and I don't know how the court wants to deal with the fact that we have a cross appeal, whether you'd like me to address that during my time now or wait until Mr. Jarbo goes and then hold some time for that and then rebuttal. Does the court care?
However you want to proceed.
Okay, so I'll just address the cross appeal while we're talking about it, because the cross appeal has 2 questions presented. One is that Judge Allen misinterpreted the contract because it should have been a contract that prohibited Mr. Buck from selling any medical equipment through the company Integra. And second, his argument is that against my argument that the liquidated damages clause is a penalty, the response is, well, basically abandoning that and saying, we didn't ask for that. We asked for what we're calling reliance damages. That's the second question presented in the cross appeal brief. As the court, I think 2 of you, Judge Bazzi, Judge Rick, had a case in the fall that identified the difference between reliance damages and benefit of the bargain damages. They're 2 separate contract theories. Benefit of the bargain is almost always used. Reliance damages are, for example, you asked me to set up a extension of my car dealership to sell more cars because in the fall you're going to give me a new line of Hondas, and I do that. I spend the money, and then you say, oh, I'm not going to give you the Hondas. And I say, but I've spent $1 million because you told me we had a contract and I spent $1 million. That's reliance damage. The court suggests that it's like a promissory estoppel theory. It's hardly ever used, honestly, in contract cases, but when it comes up, you get to put the parties back as though there was never a contract. My car dealer gets to say, I wouldn't have spent the $1 million. Please just put me back in the situation before you made that crazy promise to me. Give me back the $1 million I spent in reliance on it. We're all going to be good. That's reliance damage. That issue was not presented to Judge Allen. Was not. That was not preserved. The trial argument was benefit of the bargain. We get our $360,000 because the contract has this bargain in it. If you breach an exclusivity clause, we get this money. I argued that's a penalty. It is a penalty. Judge Allen found it was a penalty. On appeal, they've abandoned the defense of that. And instead, now they're saying for the first time, we were arguing reliance damage, but it wasn't the argument. The findings of fact, and we presented them to you, the proposed findings of fact and conclusions of law, which document the way Paragon 28 presented this case to Judge Allen, say very clearly, we ask for benefit of the bargain damage, not reliance damage. It's an unpreserved issue. Even if it was preserved, and I understand there's some debate in the courts this court about under TOLUS, how to deal with that. But even if it was preserved, there's no evidence that matches up with reliance damage theory, the way I just described it. They didn't spend any money out of pocket based on any of this. The 360,000 is the opposite of that. They paid Patriot Medical's $360,000 in the past as the payment for what Patriot Medicals did to sell a ton of orthopedic products. That's the payoff for the sale revenue generated to Paragon 28. That's the payment of $360,000. It's not an out-of-pocket expense. It doesn't fall into the category of reliance damages. So if you take all those things and the record before you, we have a situation where the damages have to be 84,000 because there's been no response. The additional damages really have to be $480,000 because there's really no response as well to that. Finally, then we get to how the statute deals with trebling and the payment of attorney's fees. Whether the amount is 4,000, 84,000.
So what's our standard? Can you remind us of our standard or review on that, please, on attorney's fees?
Well, in this situation, you're reviewing both things because there's no factual question that Judge Allen decided. It's a legal question. He erred. It's de novo review of his analysis of the statute because that's a question of law. He didn't say, I find there to be a mistake and therefore I'm allowing them not to be troubled because they just made a mistake or an oversight. That would be a factual question, but he didn't even do that.
So what did he say again?
He didn't say. He just said, I'm not giving you the trebling or the attorney's fees. We asked for it and he just issued a ruling that said no. Okay, so what we know from all the court cases under the statute is the only way a manufacturer can get out of paying the trebling. The only way is mistake or inadvertence. That's it. There's no mistake or inadvertence. Whether it's 4,000, 84,000 or more, they didn't pay because they made a conscious decision. We're terminating you and we're not going to cut you a check for September. That's because we think you're not entitled to it legally because you breached. That's intentional. There's no wiggle room for somebody to make a mistake of law and come back and say, oops, we're sorry, we were wrong to call the breach on you. That's not a mistake or inadvertence under Michigan law. It's intentional. Once it's intentional, it's mandatory that there's the trebling. That's the only way a judge cannot treble is by finding mistake or inadvertence. So then we get to the attorney's fees. And obviously the issue before the trial judge at the time was, well, it's a $4,000 recovery. I don't know what his thinking was, but even if it's just a $4,000 recovery, there is an entitlement to attorney's fees. By prevailing under the statute, which the legislature has written so as to protect people like Mr. Buck having to sue for their money that they've earned, there is an entitlement to attorney's fees. If the damage award is $84,000, we've overcome any issue about, well, you only want a little bit of money. If the award is 480 plus 84, it's certainly sufficient to justify the attorney's fees. But regardless of all that, there's no explanation in the record for not awarding them. He didn't say you spent too much time. He didn't say the hourly rate is wrong. The only conclusion we can reach is he said, I'm just not. Based on the amount of money you won, I don't have to award attorney's fees, but that's inconsistent with Michigan law. So the summary of all that is the record before you is actually pretty clean on the issues we now are presenting. The $84,000 is just a given. The $480,000 depends only on you looking at finding number 4 and saying, when I got to the end of this though, where's the math that matches finding number 4? I don't see it. It has to be done better. That's the 480. And then the trebling and the attorney's fees kind of fall with both those things. So I think I still have 3 minutes. So I'll save those.
Morning.
May it please this honorable court, my name is Carl Jarbo, and I represent the appellee cross appellant, Paragon 28. I'd like to reserve 5 minutes of my time, Your Honor. And I'd like to thank the court for having us here today and hearing oral argument today. Appreciate it. I see the primary issue in this case is whether the court is duty bound to enforce the party's contract as it's written, or whether the trial court can substitute its own judgment as to what terms of the contract are reasonable. It's really a constitutional question under Michigan Constitution, Article 1, Section 10, which protects the right of parties to contract freely. And the controlling case laws set forth by the Michigan Supreme Court in Dufresne versus State Farm Mutual 491 Mich 359, a 2012 case, and wasn't the first case to hold this. It's also Roy versus Continental Insurance Company 473 Mich 457. And what those cases establish as the rule is that when a court abrogates unambiguous contract provisions on its own independent assessment of reasonableness, the court undermines the party's freedom to contract. If the language of a contract is clear and unambiguous, there is no room for construction by the courts. Judicial notions of reasonableness are not clearly rooted in the law and therefore are not a valid basis for refusing to enforce an unambiguous contract provision. Michigan courts are duty bound to enforce parties' contracts as written, unless doing so would violate the law or public policy or traditional defense to an agreement's enforcement. In the instant case, the parties agreed year after year, contract after contract, that Paragon 28 was willing to pay an additional 10% commission to John Buck if he would reduce his product line and specifically drop the Integra product line. And Integra is a main competitor of Paragon 28. The trial court is not at liberty to rewrite this agreement and limit these restrictions to directly competing products. The contract provides at paragraph 5, and I know you've taken a look at it, but specifically, sales agent has identified on Exhibit C all non-P28 products which it intends to carry during the term. Sales agent, including all of its reps and employees, shall not carry any other non-P28 products either in the territory or outside of the territory. The commission rates set forth in this agreement include a premium of 10% of net invoice price in compensation for such exclusivity. Breach shall result in a return of such premium commissions from the date of the breach and may result in early termination of this agreement. Now, initially, when the trial court reviewed this, Judge, you had it right, he totally agreed with Paragon 28 that Mr. Buck had breached this provision, that the provision was clear and unambiguous, and that he was not allowed to carry not allowed to carry Integra. Just quoting briefly from the transcript, which was incorporated by reference into his order granting summary judgment in favor of Paragon 28 on the merits. He said, and this is at page 17 of that transcript, the written contract is clear that Buck and his company can't carry Integra. Going on, there isn't any doubt as to Coastline's and Buck's sale of Integra products. Going on a little further, but Buck clearly was a part of the contract in terms of its inability to sell Integra. It wasn't merely for non-competition purposes.
Yeah, but wasn't brother counsel, do you dispute brother counsel's contention that the judge can change his or her mind? prior to the close of
Yeah,
the.
I agree until there's a final order. That's right. But I'm just pointing out that he got it right. He said it was clear and unambiguous, and it is clear and unambiguous. The last thing I'd like to point out is he points out that with the documents submitted on the motion, that the exhibits, including the text exchange, the commission statements, the evidence of seminars on Integra products, certainly all point towards a breach of the clear agreement that Buck and Patriot had with Mr. Jarvis. So you're right, Judge. He then, on a hearing on damages, he told the parties, we'll have a hearing on damages to the extent you folks can't figure the issue out yourself. So that's what we were there for, is to show what the damages were. And then he comes out with a complete reversal, says now this provision, which is clear on its face, is ambiguous. He rewrites it to say it's only for competing products. And in doing so, he cites to paragraph 36 of the sales agent agreement, which is a non-compete clause. There is a non-compete clause, which applies after termination of the agreement. And he says, and I cannot follow this logic, but he says, because there's a non-compete clause in the contract, this provision 5, which doesn't talk about competing products, must encompass only competing products. But it's just the opposite. The fact that there was a separate clause addressing competing products after termination of the agreement shows that if the parties wanted to use competing products in paragraph 5, they could have. They knew what the term was. They used it elsewhere. But here it was simply, don't use this product. So I would say that the court, even though it had the right procedurally to change its mind, I don't contest that, but he was wrong in doing so. Now, in reviewing this issue, he also said, I refuse to enforce it because returning the commissions is a penalty, not a penalty provision. Now, there's no case in Michigan or any other state that I personally am aware of, or that's been cited to this court in any of the briefs, that says if you pay somebody something, you pay money to somebody for something, whether it be a good, service, and you don't get that good or service, and you ask for your money back, that rises to a level of a penalty. I would say if this court decides that if you ask for your money back for something that you didn't get, it's establishing new law. There's no case you can cite that says that proposition. And that's what we asked for. The complaint said we paid this extra 10%, we want it back. We told the judge we paid the 10%, we want it back. This argument that we wanted, that we never made, we never asked for our money back as our remedy in the case. I don't see how that really can be made, because that's what this whole case was about. We paid this money for something we didn't get, and we want it back. I mean, whether you use the term, whatever term you want to call it, this concept of getting your money back if you didn't get the benefit of the bargain, it's in our criminal jury instructions. It's in the civil jury instruction 142.33, this concept that you can get your cash back if you don't get what you paid for. And it's supported by this court's decision in Darby versus Macomb County, 81 Mishap 662, 1978. So the judge was wrong in finding that asking for your money back when you didn't get it is a penalty. Also, the Section 5 says that if you do carry other products, that's grounds for termination of the contract. And that's why Mr. Buck's contract was terminated. So in August when he was terminated, it was based upon that reason. And the parties agreed to that. So I don't think that there should be any claim for damages post-termination, because even if you said, no, I think this is a penalty, we're going to make that law, you still would have the right under paragraph 5 to terminate the contract if they're carrying products that they promised not to carry. Now, the issue about 3 times damages and attorney's fees.
Can you point me, so I pulled up the statute and maybe I'm asking the wrong person, but I think it says double damages. Like I'm looking at 600.2961 actions for unpaid sales commission. And in section, where is it at? I just lost it, but it says double damages, not treble damages. Am I in the wrong statute?
Judge, I'm going to let.
Okay, that's
Miss-
fine. He's coming
Yeah,
back up. I'll ask him.
because I wasn't prepared to answer. I don't have that statute right in front of me to look at with you.
That's fair.
First of all, you had asked the question, Your Honor, what did the trial judge say about this? What was his reasoning? And that's an excellent question because the transcript was never provided. He was required, if he's going to file a motion and argue this issue, which was argued on May 2nd, 2024, he was required to file the transcript even before we filed our briefs. I have not been served with a transcript from the May 2nd, 2024 hearing. I looked at the Register of Actions. I didn't see any transcript being filed with this court. And if you judges have it, I'd like to know that because I am not aware that that was provided. And so if you're not going to provide the transcript under MCR 7.210B1, this issue should be abandoned. You're required to do that. Nevertheless, I think it is a factual determination that needs to be made by the court, the trial court, whether there was an intentional failure to pay in order to bring in treble damages or double damages, whatever it may happen to be. And in this case, I don't know how you can argue it was intentional not to pay when the contract says you don't get this 10% if you're carrying Integra, to paraphrase. The judge himself, when he read it the first time, said that you're in breach. You don't deserve this 10%. We're going to have a hearing on damages. And so to come to the conclusion that somehow you intentionally failed to pay when under the contract they're not entitled to this money, I don't think would be reasonable. Also, on the issue of attorney's fees, you only get attorney's fees if you prevail 100% on your case. You must prevail on all claims, not just some of your claims, not just partly on your claims. And as it's stated in Peters versus Gurad 353 Mishap 211, 2002 case, a party must prevail fully on each and every part of their action. And in this case, Mr. Buck did not prevail. Put aside the fact that summary judgment on liability was granted in our favor, put that aside because apparently the judge changed his mind. There was no lost profit damages for post-August, which was sued for. There was, the complaint said they want over $25,000 in damages, which they did not receive. So I don't think under the law in this state that Mr. Buck would be entitled to treble damages or attorney's fees. You know, and just to go looking at the facts a little bit too on this, you know, this was really a case of deceit by Mr. Buck. He hid the fact he was representing Integra. We addressed them directly back in June of 2018. We understand you're carrying Integra. Is that true? No, absolutely not. Then he testifies at trial that, well, I put it into this Coastline company right after I was approached by Mr. Shoemaker in June. Did not explain that to us, and just hid this fact from us. In the motion for summary disposition, it was argued to the judge that the Coastline company was owned by his wife. And at the hearing on damages, Mr. Buck himself admitted, no, it's not owned by my wife, it's owned by me. So there's been a lot of deceit in this. Paragon 28's just been straightforward. They just want the benefit of their bargain. They paid for something, they didn't get it, and they should be entitled to return those funds. Thank you all.
Thank you, Counselor. Counselor, you have the 3 minutes you reserve.
Well, I'll do what I can to cover it.
So I'm looking at Counselor, he's correct about no transcript, right?
No. And this is going to take me a while, and I'm sorry if I'd like to ask for a little bit more time. The transcript, we filed in our brief to you, the explanation about the transcript. It's called Statement About Transcripts. It's in the brief. It says that we overlooked the May 2nd transcript originally, but we ordered it on January 3rd, 2025, and I think it's been filed with
May
the court.
22nd, 24.
January 3rd, 2025, of the hearing date is May 2nd, 2024.
Yeah, it's in the record.
Okay, problem solved. Okay, I'll start, it's kind of out of order, but it's important, Judge, because you mentioned it. The statute has two components of damage. 5A is the first part, which is actual damages caused by the failure. That's the 84,000. Then, if the principal is found to have intentionally failed to pay the commission when due, an amount equal to 2 times the amount. That's added to A. A plus B equals 3 times altogether. That's how we get to the trebling. And I think every case that comes under the statute, it's a treble damage statute. Let's start on the top of the arguments, and I don't want to speed through, but the issue about the Integra was resolved by Judge Allen. Just so you understand, Integra sells skin replacement products for ankles and feet. Paragon 28 sells hardware, to make it extremely simple. So Coastline Medical is out selling to foot surgeons skin. And also, would you like to buy for this other company that we're doing for Paragon 28, bolts for the ankle? And it actually is a complementary sales call, which is why Mr. Buck was doing it. He gets to see the same surgeon and present both. The court record before Judge Allen was that Coastline actually didn't sell any of the Integra products. It was a zero sale. So then the question is it a breach to carry, for Coastline to carry a skin product for the ankle? And Judge Allen decided, well, I can't read this language literally because that would stop Mr. Buck from selling pacemakers to cardiac surgeons. That's a non-Paragon 28 product. Apparently, if I read this literally, he can't do that. But nobody argued that he was so restricted that he couldn't sell pacemakers to heart surgeons. In fact, Mr. Shoemaker testified at trial, the only thing he bought was what he called mind share. Mind share is what Mr. Shoemaker, the representative of Paragon 28, thought he was buying with that clause. What did he mean by that? I want John Buck to be all in when he goes to sell my products, that he's selling my products and not be competing with my products. Mind share is not a defined term. I don't even know what he was talking about, but he said that's what we're trying to stop him from doing. Judge Allen says, well, obviously non-Paragon 28 products can't include everything. Mr. Buck has a marina. We can't include hot dogs at his marina. And Judge Allen puts this in his decision, especially about the pacemaker. Said he can sell pacemakers. Nobody argues otherwise. So therefore, it's not literally anything not made by Paragon 28. What could it mean? It has to mean the things that would hurt paragon 28, the competitive things. That's what paragraph 33 protects. That's natural. You would want Mr. Buck not to walk into an orthopedic surgeon and say, I got this bolt from paragon 28. That's pretty good. But I got this bolt from Integra, probably a little better. You should buy that one. We get that. That's not what Mr. Buck was doing. That's what the restriction was. So the contract is Judge Allen is entitled to interpret a contract. He's the trier of fact and the judge. He can interpret the contract. It can't mean literally what it says. He has to figure out what it means. He puts it in context. We can't have absurd results. That's Michigan law. It would be absurd to extend it to everything. He says, I'm not doing that. What does it really mean? It's to protect competition. And he's allowed to make that decision because the facts at trial support him. There's no clear error problem on the factual finding.
And because it was ambiguous, he made that interpretation to the detriment of the Scrivener.
He did. And it's in his findings that he did that. So, all right, I'm sure I'm out of time, and I asked for the court's indulgence just to respond to a couple of issues because they were in the cross appeal. And I don't know how you want to deal with the fact I had to do with the transcript.
Yeah, we'll give you a few more minutes.
All right, thanks. We'll make it short. We can move aside the fact that Judge Allen can change his mind. He can change his mind. There was no objection at trial to, hey, Judge Allen, you can't change your mind. He can do that. Whether Paragon 28 likes the fact that the outcome, that's a different story, but procedurally it's okay. Counsel suggested that there were affidavits that were submitted. We briefed this. It's a trial. It's a trial, bench trial. The fact that there were affidavits submitted earlier in connection with a motion for summary disposition are not part of your record. It's a bench trial review, not a motion for summary disposition review. We briefed that as well. The benefit of the bargain versus reliance damages, I think, becomes important. I think you may even heard counsel at the end say, we just want the benefit of our bargain. That's right. That's what they briefed to Judge Allen. We want the benefit of the bargain. If you breach this exclusivity, we get to take back from you $360,000. He said that's a penalty if you do that. First of all, you didn't even establish the breach. But if you did, that's too much money for what you're asking for. That's a penalty. And there's no response. The last thing, just in terms of the attorney's fees, is that where we stand now with an $84,000 at least amount of money does trigger a victory, because that was the request, to get paid the commissions at least that were owed through August and September. We don't have to get every penny, and the Michigan case law suggests to be a prevailing party anywhere, you don't have to hit 100%. That's not the threshold.
Very much, Counsel. You have 5 minutes reserved, Counsel.
I'm not going to take the whole 5, but thank you, Judge. First of all, on the transcript issue, you said, well, there's a reference. So I know that the transcript was ordered. I know that the court reporter filed a statement that said, I have the transcript at the trial court level. Only the plaintiff may come, pay for it, and pick it up. I know they filed that paper, Judge, but I don't think they ever filed the transcript itself. Oh, from May 2nd? Okay, why wasn't served with it?
I can't speak to that, obviously, Counselor, but that's why I asked for the date, May 22nd, 2024. It is in the record, which is accessible on our website by case number, by docket number.
Okay. Right, I'm surprised to hear that. Let me just double check one thing. May 22nd, you said, Judge?
Yes, the motion hearing.
Okay, so I thought the hearing was on May 2nd, 2024.
This, it may be logged in wrong, because you're right, as I look at the cover sheet, it says May 2nd, but on the way it's indicated as a transcript in the case file, it says transcript 5/22/24. So maybe that's where the issue.
I wonder if that was another hearing when we entered the judgment. Because I'm just not quite aware, but it says on the cover sheet 5-2.
It does say 5-2 on
Okay.
the cover sheet
All
of
right.
the transcript itself.
Well, then I stand corrected. I wish I would have had that to review and direct to trust directly. The only other thing I should have addressed is this claim that there's 84,000. All of the commissions were calculated by Christy Vanderkamp. She testified to all the damages calculations and had the sheet, exhibit 7374, which is in the pretrial order, which is part of the record at 109,110. And that showed that there weren't any September or October sales. So this idea, and I don't think any evidence was introduced that there were September sales. There were August sales. Those are all accounted for. Thank you.
All right, that matter will be submitted. We are going to take a 5-minute break and we will begin our 11 a.m. docket. Good afternoon. We are in the afternoon at this time. Thank you for your patience this morning. Call our next matter. Moment.
Thank you for the much needed break.
Yes.
I needed it.
Yeah, sitting here.
Thankfully exhausted, just. I felt like I needed a cut.
Oh.
I don't have to pay as much attention.
Yeah.
Exhausting.
Yesterday, we had 1/3 more the number of cases and all of them exercised their full rights for our arguments. So
Yes.
we were in until 3 p.m.
Yeah.
yesterday.
Mm-hmm. Yeah.
We'll greatly appreciate the fact that we've had coffee though.
Yes,
Mm.
thank you. All right, calling our next matter, item number 21, docket number 374793, Angela Bowers versus Jacobson Brothers LLC. Counselor, if you want to begin by just letting me know how much time you'd like for rebuttal.
5 minutes would be fine. I don't anticipate needing it, but Steve Hicks on behalf of the plaintiff appellant. It's actually Algina Bowers. I've been calling her Angela all along myself
Oh,
too, but it's
okay.
Algina Bowers.
Stand corrected.
This is a premises liability claim. There is also a statutory claim under the MCOA 554-139. This is sort of your classic premises case. It involves ice in parking lot. And I know the panel's reviewed everything and knows the facts well.
May
Let me
I
go right.
stop you to ask you a
Uh-huh.
question? Because
Sure.
it's something I've been going through the record. Were there color pictures that were provided? In the pictures that were uploaded, they're all black and white. I know that there were some pictures that were provided in the motion for summary disposition that were a little bit clearer than what we received as appendixes to the briefs, but do you know if?
Yeah, I never saw any color pictures
Okay.
on this case. I was not trial counsel. Mike might know differently.
I was trial counsel and the only pictures I saw.
Okay, yeah, we were just talking about it.
Okay. Well, pardon my interruption. Thank you
Yeah.
very much.
And I apologize for the quality of the pictures. I do wish they were better. The pictures that are in the summary disposition motion that are there are two of them in there. Those are the ones that were taken by the plaintiff's father, fairly proximate in time. And you can tell it's dark. It's darker in those pictures. And then the other pictures, which are a little better quality, although still black and white for some reason, were taken by an investigator on behalf of the plaintiff's counsel, presumably. And all of the pictures are referred to in the plaintiff's deposition. My little pet peeve is that why aren't they always attaching the exhibits at the back of the deposition so I can actually read this and look at the exhibits? So I share your frustration with that, but we work with what we have, I guess. So this is a premises claim. I know that the court knows that the standard is in the context of an ice or ice and snow case is to use reasonable measures within a reasonable amount of time. The trial court holding in this case was that that there was no breach of that duty. There just wasn't any negligence was the conclusion of the trial court. You know, and I guess one of my primary arguments here is that if this fall had occurred on Saturday, January 18th, I don't think we'd have any question that they were out there that day. They were doing work that day. There had been snow that day. But that's not the day that the fall occurred. The fall occurred on the morning of Sunday, January 19th. And this was one of those situations where you had some snow the day before, some work done on that snow and some salting done, but then a significant period of time that goes by while it heats up during the day on the 18th, and then the temperature drops overnight. And then at 8:39 in the morning, the plaintiff goes out of their townhomes there. So she goes out of her townhome and she's trying to get to her car, is what she's doing. So those are sort of the weather conditions that were going on. But what's interesting, I think, in this case, which can be gleaned from the photos, is that the sidewalk was not an available option for her here.
Yeah, so why is that important?
Well, it's important for a couple reasons. For her in particular, had she been able to use the sidewalk, she would have walked out her front door of the townhome. She would have turned left on the sidewalk. She would have been able to walk all the way down. And she was actually the second spot over. There was one parking spot with no car in it, and her car was the second spot. So she would have just gone straight to her driver door from that sidewalk.
But she fell because she was traversing the asphalt?
Here's how she traveled.
So she would have avoided the spot that was slick that made her fall?
I believe she would have. Here's how she presumed she traveled, and this is what she testified to, is that when she came out the door, the sidewalk, all the snow had been plowed onto the sidewalk. You can see pictures. I would say those pictures are representative pictures of how they plowed the snow, because they were taken later. I'm not claiming that.
Okay, that was, so this wasn't taken immediately afterwards.
Not the daytime pictures that are attached as Exhibit 8 to my brief. Those were taken later, and I don't have an exact date for those pictures. But
Wait, 1 second, just
yeah,
so
no
we all
problem.
know what you're
No
talking
problem.
about.
The ones we had, these are so much better. Like the ones that I saw,
These are the daytime.
I had a different picture in my head. That's actually helpful.
Yeah, so like. There's that. Okay, that was one of my questions. How long afterwards were those taken? But these dark pictures, then can you, I guess, give clarification? You said the dark pictures were taken right after?
the dark pictures were taken the evening of the 19th, is what the testimony in her deposition
Her
said.
dad took those.
By her father.
Okay.
She was still at the hospital. He went out and tried to document what was out there. And in fairness.
Well, I don't think they argue that they put the snow on the sidewalk. I think that what they're saying is that did not contribute. There was nothing in the record that runoff from that snow contributed. That's one of the arguments that it contributed to the fall. The other was regarding about the use of the parking lot.
And that is something the judge focused on in her ruling when you look at her written opinion. So let me address that.
Okay.
In terms of what was different in how she walked, just as a preface to answering that question, she couldn't walk on the sidewalk directly to her car door. So she had to go out into the parking lot, walk on the asphalt, and then you have to curve a little bit left and go to her car. So she's going to pass by, and this is what she testified, is that she was basically approaching, and there wasn't a car in the first spot. So she's going to her car. When she's near the rear fender, sort of the passenger door area on the driver's side is when she falls. So she's curving back towards that area. And I think
Can I stop you?
Please.
Because one claim had, maybe it was the statutory claim or the claim that was ended, or that was part of the amended complaint, which I also want you to explain to me how all that happened. But I thought I had read there was an allegation that due to the way in which the snow was piled, that contributed to the fall. And as I understood it, initially, I was left with the impression that because of the piling, she had to alter her route. That isn't the claim.
No, that is one aspect.
That
of the
is one
claim.
aspect of the
Yeah,
claim?
and that was, I was just explaining, she had to alter her route, go into the parking lot and then curve back to her car rather than going directly down that sidewalk straight to her car door.
So the point being that she would not have slipped on the ice adjacent to the car had the proper snow removal taken place?
Yeah, presumably she would not have had to go near the rear of her car.
Okay.
She wouldn't have had to come up from the rear to the car because there's no car parked in that spot. But there are basically two aspects to the negligence claim. And the judge, I think, focused on both. The first one is, let me talk about why it matters that she's out in the parking lot. There's a drain in the parking lot. And the cars where they are parked, it's slightly elevated, and you can see from the pictures that were attached. And again, these pictures were taken at a later date, so they're just representative. You can see the water draining down to her car. The defense's argument is that where she fell, where she slipped on ice, was not where the water path would be. But I don't think you can say that definitively, because certainly she is saying, I slipped on ice. It was about 2 or 3 feet of ice. I am roughly in this vicinity as I'm walking, and this is the route that I took. To me, there's a clear factual question on that as to where she fell and whether the water, the drain off that was going to occur through there because of where they plowed the snow onto the sidewalk and because of the location of the drain. So that is one theory. There is a second
Can
theory.
I ask you a question
Sure.
related to that? Now, you said she slipped at the passenger backside of the vehicle. Is that correct?
No. She's on the driver's side, but it's the rear door.
Yeah, the driver's passenger.
Oh, the
door.
driver's passenger door.
Yeah, it's a little confusing.
Okay, so my question is, which way is she parked? Is she parked into the parking spot or backed into the parking spot?
She's pulled in. She's pulled in.
She's pulled
to
in.
the
So
parking lot, in
this
my understanding.
representative picture has a vehicle that's backed in. That is not how her vehicle was that day.
Yeah, that vehicle that's backed in, I believe, is the Chevy. That is not her car. Her car is the Kia Optima, the black car. And you can see in the pictures, some of the pictures later, she's like, well, that is actually my car in these pictures and she's in the spot where she was. So
Okay, so it's not the second vehicle. I thought the second vehicle was her parking spot.
she doesn't have an assigned spot, but there's one spot and she's the second one over.
Okay.
In some of the photos, there's no car in that first spot. In some of the photos, there is a white car and a Chevy
Yeah.
that was backed in the spot that she would have used.
So her
Yeah.
vehicle would have been in the second spot where the Chevy that's backed in, but it would have been driver's door,
Yeah,
like
she's-
the front into the spot, not backed in.
Yeah, she's trying to get to the driver's door, and she, variously in her deposition says that she's near the rear of the vehicle coming, or maybe near the passenger, meaning the rear door of the vehicle. They go over it a number of times in the deposition, but what she's very clear on is that there was an ice spot. It was oval in shape, 2 to 3 feet, and the defense's argument is primarily, and I think the trial judge agreed with this argument and found that there just wasn't evidence that she fell where the drain off was occurring. But we're looking at pictures that are just merely representative. Her testimony was that she slipped and fell on ice. She testified as to a rough area where it was, and the photos show drain off in that area.
Well, and the
So-
water isn't gonna, go down in an orderly fashion necessarily.
It doesn't
but-
tend to do that. So
And then you have ice being piled up in common areas that are supposed to be available for the tenant's use.
Yeah, it would have been better had she been able to use the sidewalk, go directly to the car where she liked to park her car. But that was not the case here. But there are really two theories that get you to a fact question on negligence here. The first one we've already talked about, which is the plowing of the snow and the drain off. But there also could be just an ice patch that forms overnight there, because there was snow the previous day. They attempted to remove it. Sometimes you get all of it when you're plowing. Sometimes you don't get all of it. Sometimes there's a car parked in that area. You're not able to get it. The real issue is whether they took reasonable measures on the second aspect of this thing, the second sort of theory. The question is whether they took reasonable measures within a reasonable amount of time to ameliorate ice that could form overnight. They knew it was hot the day before. In fact, they've acknowledged as much because they salted that day, and they say they were salting in advance to do that. They were, I don't know, you call it pre-salting or something. I don't know whether that's effective or not. But there's a time lapse when it gets cold until she goes out in the morning. Nobody looks in the morning. I kind of jokingly said in my brief that, on Saturday they worked and on Sunday they rested.
Right.
Because that's really what I think happened here.
Well,
Go ahead.
I think part of what was persuasive to the judge was, well, what else could they have done? They weren't, it wasn't like they never cleared the snow and never salted. It was still fairly early in the morning. So what's your response? I believe that was part of their briefing as well to us. What is your response?
Yeah, well, the test is reasonable measures within a reasonable amount of time. She doesn't go out there till like 8:30 in the morning. No one even checks on on the one hand, they say, we know there was going to be a problem with ice, so we pre-salted. On the one hand, they say that, and they did that on Saturday. But on the other hand, they say, but we didn't do anything in the morning and we didn't have to, that was we were required. I think that's
And that gives rise to your question of fact.
that's my
then?
question of fact. I'm not saying we're right. I'm not saying they're, either way. But it's for a jury to make that determination on that aspect of the claim. So that's basically the premises claim in this case. There is also a statutory claim. I'm not going to spend a lot of time on the statutory claim, but I think in some ways it's kind of an interesting one because she does fall in a common area. She falls in the parking lot. So we know that it's 554-139-1A. We know that the test is whether it was fit for the use intended by the parties. And then we have a big hurdle in the way, and that's the Allison versus AEW capital case the Supreme Court came out with many years ago, in which they said, yeah, but a parking lot its primary purpose isn't walking. Its primary purpose is parking. So it just needs to be fit for parking and I guess give you a reasonable access to the vehicles. Now, I would argue Allison was wrongly decided, but obviously that argument doesn't get me anywhere here today. But what's interesting in this case is she never would have been in the parking lot had she been able to use the sidewalk.
Oh, wait a minute. Wasn't Allison in the context of open and obvious?
Allison was not, because it's a 554-139 case. It's a statutory claim, and open and obvious, even back in the day, even before Candle El Sayed came out and changed open and obvious, 554-139 cases were not subject to the open and obvious defense. The test was whether it was fit for the use intended. So what's interesting about this case is she would have been on the sidewalk. What's the purpose of the sidewalk? The purpose of the sidewalk is to walk on the sidewalk and use it to get to your car like she would have liked to have used that day. But they forced her into the parking lot. Does that in any way distinguish Allison? I think it does. And that would be the argument that I would make. I would also make the argument that with the ice in the parking lot, and to the extent it was formed by the way they plowed and the way it drained into that parking lot, it wasn't fit for the use intended. In Allison, there was just a snowfall. And they said, snowfall is going to happen. It's still fit for the use intended. Well, here we have something different than that because we have this other issue of the drain and the manner in which they plowed at play. So I would say that it wasn't fit for the use intended, or at the, and that there would be a fact question on that as well. Just to answer, I think Judge Rick had a question about the complaint. This is really, I don't think it's a real issue in this case. There was an amendment of the complaint to add a nuisance claim. I haven't pursued the nuisance claim on appeal. There also was the first theory that they plowed the snow in a way that created the hazard. I tend to think of that as being an ordinary negligence claim, but the appellate courts have told us repeatedly, if it's a condition on the land, we're going to treat it as a premises claim. So it was treated as a premises claim in this case. There was not, to my knowledge, an ordinary negligence. So. So
My
that-
question was procedurally, I
Oh.
was confused. What happened with the amended complaint? Because it seems like it was never formally accepted, yet the trial court disposed of it.
Yeah, there is that, it is strange the way it played out, but I don't think it matters because I didn't pursue the nuisance
Okay.
claim on appeal anyway. I don't think there is a viable nuisance claim here,
Okay.
so I don't think there's any reason to go there. All right,
Helps.
thank you.
Thank you.
Thank you. Counselor?
Good afternoon, Your Honors. Michael Cafferty, P36613, on behalf of the defendants.
Good afternoon.
Nice to be in front of all three of you. I'd like to clear a few things up just right off the bat, since this has been my case since the beginning, so I think I know the facts pretty well. This whole issue of the sidewalk, I don't think that was really argued very extensively below, and it doesn't really make any sense at all. Her deposition, as I cited in the brief, I think it was around page 22 of her deposition, she fell standing next to her car, getting her keys out to get into her car. So to say she was forced into the sidewalk, I guess I was forced onto a sidewalk, or, forced into the parking lot. I'm sorry, I misspoke. I live in a condo in Dearborn. I'm forced into the parking lot every day when I have to go get in my car. I was forced into the parking lot this morning. You have to go into the parking lot to get into your car. The path of the so-called snow melt, one of the arguments that they raised had absolutely nothing to do with this fall. To get into your car, you have to stand next to the door, you have to open your car and get in. That's what happened. She fell getting into her car. So,
But explain to me your snow melt. Was that your question?
well, the snow melt, so this picture, it's in the appendix 164. So if this would have been the position of her car, although her car wasn't backed in, the snow melt goes to the drain. We can't change the rules of gravity. You have to have the drain somewhere lower so that it melts. Otherwise, you have an ice skating rink in your parking lot, which is great for those of us who play hockey, but for everybody else, it's not so great.
But if you know that, and if you know you've had bad weather, and if you say we've prophylactically applied our salt, doesn't that give rise to notice here that?
Notice of what? They spread 3,700 pounds of salt the previous day when it was 39 degrees outside, because they saw the weather reports that suggested that there was going to be cold weather that evening. It was well above freezing. It was 39 degrees on that day. And they spread the snow in anticipation of
The salt.
the salt, in anticipation of the freezing. And, and council says, well, it's great. They did all this work on Saturday, which was great, but they rested on Sunday. Well, if you look at the report for Sunday, for example, the weather report from the apartment appendix, page 112, there was no precipitation on Sunday until noon. And the whole day there was 0.2 inches of snow. And it was between noon and 12. She fell at 8:30. In terms of like a lack of factual support for their claim, the judge, and Judge Lillard is not exactly a great, judge for the defense. I love her, but she's more plaintiff oriented than defense oriented. And Judge Lillard's like, the facts are undisputed. It was 39 degrees the previous day. There had been less than an inch of snow that day. They called in a crew to work overtime. 5 people were called in to work overtime to spread 74 pallets of salt containing 3,700 pounds of salt. They spread it everywhere throughout the parking lots. They even testified we threw handfuls of it between cars to get it everywhere we could. And there was no snow. There was no snow between them doing that and the next day at noon.
But did
And
they know the snow was going to melt and it was going to head in the direction of the parking lot, and that's where people have to walk?
The snow wasn't going to melt because the temperatures were dropping. So if anything, it was going to freeze. That's why they were spreading salt. It was 39 degrees at 5 o'clock on that Saturday. The plaintiff herself admitted, and this was an important part in the record below, the plaintiff herself admitted when she came home that night, Saturday night, there was no ice anywhere. There was no ice. So that ice, she said that ice could have formed literally a minute before she fell. So there was no ice anywhere.
So does that rise to the level of a factual dispute about reasonableness? I mean, that's what,
No, I
isn't
really,
that something the jury should decide if it was reasonable? Should they have had the crew back because
there was no new snow. What would the crew have done? We spread 3,700 pounds of ice the night before. She admits when she came home that night, I think she said she went to a movie. She came home that night at whatever, 9 or 10 o'clock. And I asked her, was there any ice? Was the parking lot icy at all? No, there was no ice at all. There was no snow that night. It didn't snow on the 19th of January until noon. So why would you call the crew back in the middle of the night for more overtime? They'd be saying, hey, boss, there was no snow. Why are we coming in to spread more salt? We just spread 3,700 pounds of salt. There's been no precipitation, and you're telling me to come into work to spread more? I mean, it really doesn't make any sense at all. And the snow melt thing doesn't make any, and don't get me wrong, I'm not one of these fire breathing defense attorneys. I do more plaintiff's work than defense work, but I wouldn't have touched this case as a plaintiff's attorney. The snow melt issue is, I mean, you can see the path of the melt. This is 164.
But where's that? I'm looking for that picture. I have the
It's
closer one.
164 of the appendix.
Of
your
Your
appendix
appendix?
or?
I think it was his appendix.
Okay, I was gonna say, because I wasn't saying
Yeah, so-
appendix.
And let me just address the sidewalk issue, because that's another one that's actually somewhat absurd. The sidewalk ends, right here. There's no way you could have a sidewalk going to the side of her car unless it like magically went through the cars. There's no way to put a sidewalk there. If you look at the appendix picture 162, the cars are up at the elevated portion and there is no sidewalk there. There's grass and trees there. So
There's not a sidewalk that runs in front.
the
of
sidewalk
all
runs in
the
front of the
parked
buildings, but
cars?
it stops when you get to the parking lot.
Okay.
And these are up against the trees and grass. So if she walked around the other way, along the grass and trees, she still ends up at the same spot next to her car, getting her keys out where she says she slipped on the ice. So there was the record is clear that there was no precipitation that day, and they don't dispute this. They don't dispute the fact that we had a crew in working overtime to spread all the salt in anticipation of, and I've never seen a condo or apartment complex that's this diligent, that like, let's get ahead of this and get a crew out here to get ahead of this weather. So they did that. There's no evidence that there was any snow that night. There was no more precipitation. There would be no reason to go spread more salt. So unless you're willing to change the law and say strict liability, if you fall in my parking lot, you're liable, period. Doesn't matter how diligent you were in taking care of everything. I mean, there's really nothing to try here. And that's why even Judge Lillard said, this case has got to go. So, let me just take a quick look at my notes, but.
So can I ask you something?
Sure.
Picture 162 of the appendix.
Yep.
There appears to be, here, let me show it. Here it is right here. There you go. We're all looking at it now. Do we know if that area was covered with snow where she could have, like you were just indicating, it's all vegetation?
Well, you can see
Was
the
there any
trees.
testimony? Yeah. Was there
Yeah.
any testimony of how the snow appeared regarding maybe kind of the edge of that grassy area?
Since this is representative and not.
Yeah, I
timeline.
don't think there's any evidence of that, but when you look at that picture, that this is grass here, the sidewalk ends here. She didn't fall here. She felt it would be out of the picture next to her car. So regardless of whether she had to transverse any path of the snow melt, which she wouldn't, because the path of the snow melt is heading down toward the bottom of the parking lot. It's heading down here to the drain. So it would be going this way. She would have walked this way to her car, got in her car. So she wasn't where she fell. She didn't fall in the middle of the parking lot
Mhm.
where the path would be. She fell next to her car and she would have been there whether she,
So in any circumstances, she would have had to go into the parking lot to
Yeah.
walk to her
yeah,
vehicle.
she'd have to stand next to her car to get into her car. And that's where she fell. When counsel said there's a fact question where she fell, there's not. She said in her deposition where she fell. She said she had her purse in her hand. She was at the side of her car, driver's side of her car, getting her keys, and she fell. So it's an unfortunate accident. She had a fractured leg. It's unfortunate, but there's just no path towards showing negligence on the part of the apartment complex.
Can you address the issue of the statutory claim and whether council has cited, and you may have both acknowledged the Allison case?
Yeah, that's in my brief. And yes,
And to the extent that it is now fully acknowledged that every tenant must utilize the parking lot to walk to their vehicle, does that elevate the duty here under the statute?
no, because the Ellison case, the Supreme Court in that case said that the mere presence of any snow or ice in a parking lot does not mean that it's not fit for its intended use. That statute is basically, is it fit for its intended use? And Ellison dispositively held that the mere presence of ice and snow is insufficient to say that it's not fit for its intended use.
But
We
my
live in a-
point is, intended use here seems broader than Allison's intended use, because we now know there is no area that the tenants can traverse other than the parking lot.
Every
Because you
car's
don't
in a
have a
par-
sidewalk.
But just take a look at parking lots, like the parking lot that I parked in over by the Fisher Building today.
Mhm.
There's not a sidewalk that would lead me right to my car door. That you can't design a parking lot that gives you a sidewalk up to your door. You have to be in a parking lot. You just can't.
I don't know, have you
You know-
shopped at Costco? I mean, seriously, they have those little lanes where you can take your cart into the parking lot, right?
Yeah, but when you walk up next to your car, my car's here, I'm next to my car. I mean, she didn't fall on the sidewalk. She didn't fall in the area of the snow melt. She fell getting into her car, which is.
I mean,
yeah,
she's letting you in on what we're struggling with and giving you the opportunity to respond.
Yeah, I'm
It-
trying to respond.
No, it's the question of whether or not placing the snow, and I know you're not connecting these things.
Yeah.
But once you eliminate the common area that's for walking, suddenly her question was, does that change your responsibility as it relates to the parking lot, irrespective of where she's
Yeah,
lived?
I don't think so. In terms of placement of the snow, we all, I think there's a disconnect here. And part of that disconnect is this wasn't a big giant snowstorm with feet of snow. There was no snow. Between the time they spread all the salt and the time of the fall, there was no snow. So, and the day of the incident, the weather report shows there was 0.86 inches of snow, so less than 1 inch of snow.
The weather reports say what the temperature was over the night.
Yeah, that was in the record.
that was
It dropped. So
admitted.
it got on the Saturday before the fall, it was 39 degrees at like 5 o'clock. She's out to the movies. She comes back at 9. She says it's
Mhm.
still, there's no ice or anything there. There's no snow, there's no ice. So it was 39 degrees on the Saturday at 5. And then it dropped overnight. And I think by the morning at 8:30, it was like 18 degrees. So we did have a big drop in temperature. And that's why my people testified that they monitor the weather every couple hours. They saw that cold weather was coming in. So they proactively went out and put 3,700 pounds of salt throughout the parking lot. I don't know what more they could have done. They spread it between the cars. They put it everywhere. So there wouldn't have been this snow melt from the snowbanks. And if there were snowbanks, and we don't know if there were snowbanks because those pictures that they have were from months later. So if there were snowbanks that day, they certainly wouldn't have been melting when the temperature dropped down to 18. So there wouldn't have been any kind of like, well, the snow melted and you created like a path and then it froze. Like, no, it's like we spread all this ice in anticipation of the coming freeze. There's really, I mean, where's the negligence? So, sorry for being so vehement, but I mean,
No,
yeah.
I mean, obviously, as
But-
Judge Maldonado indicated, we're all struggling with this.
Yeah, I mean, I just wanted to make it clear that this isn't a situation where there was a big snowstorm and they should have come back and done some more shoveling or done some more salting. There wasn't a big snowstorm. They just put down the salt in anticipation of the cold weather. It was unseasonably cold. It's January 18th, 2020, shortly before pandemic, and it's unseasonably warm for January 18th, 39 degrees. So it's nearly 40 degrees. They see that it's going to be getting cold. They call in the crew. This is all undisputed. They call in the crew. They spread 3,700 pounds of salt throughout the parking lots. And then and she fell at 8:30. So were they supposed to come in the middle of the night just because maybe there's going to be a patch of ice forming? I asked her in a deposition when you got there Saturday night after the movies, there was no snow or ice, or there's no black ice. You had no problem in the parking lot when you got out of your car. No, I didn't. Do you know when it formed? It could have formed minutes before I fell. She admitted that. So, I mean, what can an apartment complex do? Unless you're willing to change the law and say there's strict liability. If you fall in a parking lot, they're liable, period. Beyond that, I just don't see a path to victory here. So again, thank you. And
Thank you.
I have a lot of respect for how you guys can sit through these exhausting arguments. But thank you.
We're gluttons. I'm a
Let
glutton.
me-
They're not gluttons.
Let me reset your time. 1 moment.
As you can see, we're taking all of your arguments very, very
So,
seriously.
yeah.
Doing the work.
Counselor, can you address this issue of the sidewalk? And it appears, and going over Allison again, as long as the sidewalk itself is fit for its intended use, then that is what their obligation is. But here, it doesn't appear that there would have been a sidewalk that would have taken her directly to her vehicle. And so was the fact that there was snow or there could have been snow on the sidewalk. I know the pictures aren't representative of what happened. The pictures don't represent what it looked like exactly in the day, but are representative of that. I guess to counsel's point, she would have had to go into how does the snow on the sidewalk really impact our decision when it's clear that she would have had to go into it anyway?
Yeah, factually, let me clarify that because I think it does get confusing. The testimony is a little confusing. I think there's a factual dispute on this. Here's what it is. If they plow onto the sidewalk, which by all indications they did, the plaintiff said that's what they did. They acknowledged do. So those are representative pictures, but they're representative of how they do their plowing. So we can presume that there was snow on the sidewalk. And her testimony is that too. So what's the difference? The difference is, I don't know how many feet it places her to the right, but it places her out into the parking lot. And as she's coming through that parking lot, knowing there's no car in the first spot, she then has to walk towards her car, get her keys out, and open up the car door. She never reaches, she doesn't reach the car door and open up the car door. She falls before that. And I had flagged some of her testimony on that. She said, Mike asked, were you at the back door? Were you at the door of your car? No, I was by the back. The back driver's seat, the back driver's door, I'm sorry. So Mike asked, so you had not got to your driver's door yet? No. And that's on page 22 of her deposition. There are other times that they go into this. They go through it several different times. The direct route for her, had there not been the snow on the parking lot, it would have been to walk down that sidewalk, and then she would have had to cross that first parking space to get to her door. So her angle, I guess you could diagram this out. Her angle would be from the end of the sidewalk directly to her door, presumably, because she didn't testify she was going to her trunk or anything. Whereas because of the way they plowed it, they put her out in the parking lot It's a different angle, cross over that, that wet area where the snowbank is going to melt and float, naturally flow to that drain. So it's,
Sorry, I'm not that great with visuals.
Yeah.
So the sidewalk, so if this is the building, jeez, and the car, let's see, this is the building, the car's parked here. Does the sidewalk go like, would it hit the car, like if the car is parked here, is the sidewalk ending like here, or does the sidewalk go out this way?
the sidewalk, if she walks along the sidewalk, if there were a car parked in the first space, she would probably be at the back of that car,
Okay, so the sidewalk goes out to the back of that
the
first.
first space.
That helps me, thank you.
But then she has to get to her car. So from there,
Right,
she's going to
okay.
turn and go straight to her driver's door. Whereas what she had to do in this case, I don't know how many feet, let's say 10 feet out into the parking lot, is a completely different angle to get to her car. She has to cross over that drain area. So that's sort of the rub. Now, with regard to,
Okay.
with
I see
regard
that.
to, with regard to Allison and whether this somehow changes the duty, because Allison's, not particularly good case for me. He quoted it correctly when he says the mere presence of snow and ice is not going to be enough to make it not fit for the use intended. Why is that? It's because the parking lot, they focus on the purpose of the common area that you're in. And different common areas have different purposes. For the Supreme Court at that time, they said parking lot, primary purpose is just parking your car. Now, I don't know how you get to the car, you levitate over to it or something. I've always had that issue with Allison, but they're like, well, I guess you have to give them reasonable access to the vehicles. That's sort of a secondary purpose. So the getting to the vehicle, the walking is a secondary purpose. That's not true of a sidewalk. A sidewalk is for walking. And that's what she did. And that's what she would have done and been able to do in this case. So I don't know, does it make Allison distinguishable? Does Allison need to be challenged as to whether it was correctly decided? That's obviously an issue too. But our primary argument is the premises liability claim. Let me address two things that were mentioned. It sounds like a lot of salt, 3,700 pounds. Seems like a lot of salt.
I mean, it seems like they did do a lot.
It's 450 units. These are townhomes. This is a huge complex. Is that a lot of salt in the context of that? They said it's a little more than they put out normally, but I think that's all that we can say. So I think the shock value of the amount of pounds of salt really goes away when you take into context. And I went and looked at an aerial view of the complex. It's huge. So I think that takes away some of that. But the real issue I think counsel focused on in his argument is what was the crew to do? I have a pretty simple answer for that. I mean, they have people that live on the premises. Somebody's got to peek their head out in the morning and say, how's it look out there? We did that stuff yesterday. Is it holding up? Is it decent? Walk the grounds, take a look around. It's not sufficient to say, well, we don't have to do anything unless it snows again. They needed to take a look around, and they know that they needed to, because they acknowledge it was hot the day before comparatively for January. It got up almost to 40. And then it dropped overnight down into the teens. So they knew this was going to be a problem. Was pre-salting going to take care of the problem? I mean, I'm not an expert on this. I think pre-salting might work if you do it right before an ice storm or something. But if anything, it's just going to maybe melt what's there, create water, and then it's just going to freeze again. The important thing is you got to take a look at it in the morning. So that's what I argue that they should have done. Hopefully we've been able to clarify some of those things. And the bottom line is I just think it's a fact question. Thank you.
Thank you. Thank you both.
Thank you.
Thank you.
This matter has been submitted.
Well argued by both.
Yes, thank you. All right, turning to our next matter, item number 22, docket number 372017, is it Graciela Bruner versus Alicia Danielle Caldwell. Good afternoon, Counselor. How much time would you like for rebuttal?
Good afternoon, John Akis on behalf of plaintiff appellant. I'm actually gonna ask 10 minutes. I think the way this is gonna go down, and there's some things have changed since all the briefing, so. In short, since all the briefing happened, Mary Freebed came out, Tarhanich came out, Maher Mar came out. All of them said same thing. You do proceed down the order of priority in motorcycle cases. I don't see anything about this case. I know opposing counsel is probably going to argue about the contract language. That I don't think that's preserved, and I don't think the contract language trumps the statute. I think that's well established. So I'll handle most of that in rebuttal. And then as far as the UIM stuff goes, I think that opposing counsel is probably right. Had they argued the whole time through that this was a commercial policy, the motorcycle is not a vehicle listed on the commercial policy. But that's not what was argued in the trial court. What was argued in the trial court was that Ms. Bruner's husband was a named insured. She then constitutes a family member of a named insured, and the way the UIM policy is written is such that she would then be entitled to coverage regardless of what vehicle she's in.
You have more than 10 minutes left.
Hi, I was going to say good morning, good afternoon. Brianna Combs on behalf of Defendant Appley Federated Reserve Insurance Company. The trial court reached the correct result here in granting summary disposition to Federated on the PIP claim. I recognize this court recently decided Mary Freebed. I know Judge Bazzi, you're on that panel. What Mary Freebed says is that you can proceed down the order of priority under the statute MCL 500-31145. But here, different from Mary Freebed, different from the Tarhanich case, and different from the Maher case, we have an applicable exclusion in our policy that applies here that we argued both in the trial court and in our brief on appeal. And that exclusion says, we will not pay personal injury protection benefits to you or any family member while occupying a motorcycle if the owner, registered, or operator of the auto involved in the accident has the required Michigan no-fault coverage. That exclusion applies here. Plaintiff is made
preserved.
Yes, Your Honor. It was argued in the trial court and it was argued in our appellee brief. Plaintiff makes no argument on appeal that the language in that exclusion does not apply to the circumstances we have here. Instead, what plaintiff argues is that Federated cannot rely on an exclusionary language in its policy to avoid providing, quote, statutorily mandated coverage. Respectfully, this argument is fundamentally incorrect. Motorcycle coverage is not statutorily mandated coverage. And in fact, in the Mary Freebed opinion, the court said just that. At the top of page 6 of that opinion, it says motorcyclists are not legally obligated to purchase PIP insurance. What that means is that insurers of motorcyclists are not obligated by the No-Fault Act to provide no-fault coverage to motorcyclists, which in turn means that Federated was free, consistent with the No-Fault Act, to condition the coverage that it had in its policy on an exclusion like this one. Also important here, I think, is the Mary Freebed opinion also says that the statutory scheme under MCL 500-31145, quote, aims to ensure that motorcyclists will be able to obtain no-fault benefits from at least one no-fault insurer. And that's exactly what our exclusion did here. The exclusion said, we only exclude coverage if you have coverage already under the policy of the motor vehicle owner operator, which is what happened here. So this exclusion applies under these circumstances. So what I think here is plaintiff is trying to take Mary Freebed one step too far. Mary Freebed does not say an insurer must provide PIP benefits to a motorcyclist under all circumstances. What it says is we have an order of priority. If you exhaust at the first level, you can look to the next level, but that does not mean that when you look to the next level, that policy must provide coverage.
I'm sorry, maybe I'm missing it. Where was it preserved? You said, where is it raised in the lower court?
In the summary disposition briefing. I can find that for you. It might take me a second.
It's fine. I can look for it. I didn't see where it was.
And I can,
That
fi-
particular argument. was
and I'm
preserved.
happy to file a supplemental brief if that would help the court and point the court right to it. Thank you. So that's my argument on the PIP claim. And then, like I said, the Tarahanich and Maher cases that came out after Mary Free Bed, I reread those opinions again, and neither of those cases discussed an exclusion. So those cases are distinguishable on that fact that they didn't have an exclusion like we have here. And then in terms of the UIM claim, I think we lay this out very well in our brief. This is optional coverage that's dictated by the language of the policy and not the No Fault Act. And we were very clear in our briefing. I'd like to correct opposing counsel. We absolutely argued in the trial court, and this I can point directly to. This is at plaintiff's appendix, page 224, that we argued that the named insured on the policy is a corporation, Bruner Plumbing and Heating Company, not an individual. So therefore, the definition of insured for a corporation is what applies here. And in that context, under that definition, it requires that that plaintiff was occupying a covered auto, and the policy's definition of auto does not include a motorcycle. There are actually two other sections of the policy that explicitly exclude motorcycles from the definition of auto, and plaintiff in fact admitted this in the lower court. This is at plaintiff's appendix 239. Plaintiff admitted, quote, motorcycles are excluded from the definition of auto. Plaintiff also repeatedly admitted in the trial court that her motorcycle is not an auto under the federated policy. This is at plaintiff's appendix 236, 239, and 240. So where plaintiff admits that she was not occupying an auto, whether covered or uncovered, she is not entitled to uninsured or underinsured coverage under that, under the policy.
Oh, that's a contractual term. And I mean, we don't let litigants define those. Right? I mean, so her admission, I guess, is not persuasive to me.
Okay, sure.
So
I guess I would just point back to the two places in the policy where the policy explicitly says motorcycles are not included in the definition of auto. So we have those two things, yes. And then as a secondary argument, even if this court were to agree, the definition of insured under the endorsement for individuals applies, which we certainly agree that it does not, because the declarations explicitly says that a corporation is the named insured under the policy. But even if we were to get to that second step, there's a exclusion in the endorsement that would apply here. That's at our appendix 047B that says it excludes uninsured or underinsured coverage when any family member is occupying any vehicle owned by that family member that is not a covered auto. So then we get back to the same thing. The motorcycle is not a covered auto under the policy, so this exclusion applies. So I think either way you look at it, whether it's a corporation, which is what we argue in the declarations, if that definition applies, it's not a covered auto, no coverage. Even if plaintiff is right and somehow you get to the definition for an individual, there's still an exclusion that applies. So either way, we reach the same result. Is there any other questions I can answer? Thank you.
I'll try to be pretty brief again. The main point I would make on the PIP side of this equation is that in Mary Free Bed, the court cited to MCL 500-3107C6 which plainly says that if there are two or more policies, and doesn't talk about priority all, but just says if there are two or more policies applicable to a crash, then you get up to the highest limits available from any one policy. And that's what the court kind of used, at least in large part referenced, to establish that you can continue down the order of priority or as additional support for that. And in this case, if their exclusion is allowed to apply, it would directly contradict the plain language of that statute, which says that they must allow up to the highest limit.
If they're available. I guess the point is, if it's not available,
Mhm.
then it's just not available. I don't see the contradiction you're referring to.
So the contradiction would be that the way I'm reading that language of that statute is the crash occurs. What are all the possible policies that could apply to this crash? That's how I think 3107C6 works, is you look, okay, what's the total possible policies. Okay, this one's got 250, this one's got 50, this one's got unlimited. Okay, then the total coverage has to be unlimited, is how I'm reading that statute. Whether or not you agree, I don't know, but that's my read of it. And then you continue, and then you turn to 31145 and go down the order of priority, starting with the highest priority insurer until you reach whatever the threshold limit is amongst all the policies. The other thing I'd point out is, I cited in the reply brief, but Rollman v. Hawkeye, and Northland Radiology was more recently in this court, but it's pretty well established that for PIP coverage, which is statutorily mandated coverage, regardless of if it's a motorcycle or auto crash, doesn't matter if PIP applies, it's mandated by the statute. And then further in Harris v. Auto Club, which is 494 Mish at 642, I believe. That's a specific motorcycle case that went in front of the Supreme Court in 2013. And the Supreme Court said it very explicitly that PIP in motorcycle cases arises solely by statute. So I don't know how you could have policy language come in and say, okay, we're going to say the statute doesn't apply, saying that you should be able to get unlimited when there's an unlimited policy. The other point I was going to make is, as far as both, I don't think either the PIP issue that we're talking about, the exclusion, the PIP policy, or the exclusion or the possible business named insured issue, I don't think any of those were actually preserved in the trial court. And typically, as the appellee can ask for affirmance on other grounds. That is the thing this court will grant at times. However, under the Mend the Hold doctrine, the defendant in this case is an insurance company. They have a duty of good faith to their policyholders, their insureds, to tell them, here's why we're denying coverage. They can't just constantly be moving the ball and changing the goalposts on their insured. In this case, they said, the reason we're not paying for PIP is because we don't think we have to under priority. And the reason we're not paying for UM/UIM is because of this whole auto issue. They didn't talk about the anything to do with the exclusions that they're now citing to, or the named insured issue in the UM/UIM. Cool.
Thank you very much. This matter has been submitted. Turning to item number 23, Huntington Ridge Farm, Inc. versus Devoted Friends Animal Society Incorporated. Good afternoon, Counselor.
Good afternoon, Your Honors. Stephen McKenney on behalf of Huntington Ridge Farm.
Can you please let me know how much time you would like for rebuttal?
I'd like to reserve 4 minutes for rebuttal, Your Honor.
All right, thank you very much. You may proceed.
Huntington Ridge Farm is asking this court to reverse or vacate 2 orders of the Circuit Court on Appeal. And the reason we're asking for that is essentially 3 reasons. Number 1, the case is moot. My client sold the property. There's no relief that can be awarded against them. Number 2, the issue of possession after the land contract forfeiture has already come up to this court on appeal. This court denied the application for leave to appeal. That issue has been adjudicated and litigated. Third, what the district court did on remand the first time from the Circuit Court, entering the judgment non-pro-tunc, was absolutely appropriate under the circumstances. Any of those 3 reasons justify vacating and reversing the Circuit Court's decision on appeal. I just want to go briefly through them. Number 1, on the mootness issue, as I said, my client sold the property, and it didn't sell it by surprise. It was a litigated issue. Devoted Friends actually placed a lis pendens on the property. We had to have that lis pendens removed. It was removed by the Circuit Court. Then my client went ahead and sold the property. There's no relief that if we went back to the district court that could be awarded against my client. My client doesn't own the property. You can't make somebody put somebody back into possession of property they don't own. The other issue would be, at this point, the land contract expired 2 years ago. The total amount was due and payable 2 years ago, was never paid. So there's nothing to be redeemed in the district court either. We also cited the Caswell versus Rogers case, very similar circumstances where a court had approved a sale of a property. And the tenant came back and said, well, I have a leasehold interest. And the court said, it's too late. There's no relief that can be afforded. The case is now moot. And I think the mootness issue probably ought to prevail. It's a jurisprudential issue. Court shouldn't just answer questions for academic reasons only. If you can't award relief, the order should be vacated. On the possession issue, again, just so the court is clear, the possession issue was tried at first. The possession judgment gets entered in July of 2022. The eviction probably should have happened in November of 2022, but there was a stay obtained. The stay was obtained so that there could be a delayed application for leave to appeal the possession issue. That delayed application was denied by the Supreme Court or by the Circuit Court. An application was taken to this court. This court denied the application. The possession issue was decided back in January or February of 2023. The attempt here is to take the money judgment and appeal the possession issue a second time. That's not allowable under the law of the case doctrine, as we noted in our brief. The third issue I want to raise is that even if you set aside those first two issues, what the district court did on its remand from the circuit court in entering the order nunc-pro-tunc was absolutely appropriate, because the circuit court or the district court had said back in July of 2022, when it first heard the possession issue, it was going to issue a judgment of possession that day. Everybody absolutely agreed that that's what was going to happen. The form order didn't get entered. A substitute order was entered that was consented to by all the parties. That was entered. Correcting the form of the order is exactly what nunc-pro-tunc relief is for. It happens all the time on remand for appeal. So that's another reason why we think the district court got it right and its decision should never have been reversed in the first place. If there are any questions, I'm happy to answer them. Thank you, Your Honors.
Questions? Thank you very much. Good afternoon, Counselor.
Good afternoon. May it please the court, my name is Mike Gilner and I'm here on behalf of Devoted Farms. I don't think it's an overstatement or an exaggeration to say that there are some significant constitutional and public policy reasons underlying a land contract judgment. A judgment, after all, affects property interests. It has the effect of dispossessing a tenant or a land contract vendee and terminating their interest in property. Therefore, before that can happen, the judgment must be explicit and clear about how disposition can occur. And that is important so that the tenant or the vendee knows what he or she must do in order to stop dispossession. And they must know that in advance. It does the tenant no good to tell them after the fact what they could have done to redeem the property. Therefore, that notice should be advanced. It should be given before dispossession occurs. Here, the trial court's order subverted those considerations. In the first order in November 2022, the trial court advised the parties that its July 22 order constituted a final, not a final judgment, but a judgment that had the effect of dispossessing my client.
I don't want to interrupt you, and maybe you can come back to this argument, but how is this case not moot?
It's not moot for the reasons I stated in the brief, which is the party claiming it is moot cannot take some action and then use that as a basis for an appellate parachute. They sold this property not to a bona fide purchaser. It was someone who knew that the litigation was pending, bought it anyway. Now, my client can't take any action on that until this issue is resolved. If this issue is resolved, we have a claim against Huntington Ridge and potentially that purchaser who does not qualify as a bona fide purchaser.
That issue been litigated already?
It has not been litigated.
Possession of the property?
The The possession was resolved in the July 22 order. Okay, that was resolved as part of an interim order. But the July order also said, you know, we have to have trial and we're gonna, take care of these other things in the meantime. But the issue about this purchaser has not been litigated, other than they filed a motion to quash our notice of lis pendens. And we argued opposed to it. We preserved the record on that. The trial court disagreed with us. Before we can do anything on that, Your Honor, we have to have a decision on this. And then we can undo that transaction. That's a mess, I recognize, but that's a mess that Huntington Ridge created and the trial court allowed to happen. And it should not have happened. So, as I said, the November order devoted after the fact. Now, wait a minute. Your right of redemption has already passed. That was set aside. Here we are. And in February 2024, the trial court essentially did the same thing. When you make it nunc pro tunc, you are telling the vendee after the fact, your ship has sailed. Too late to do anything with it. And so I think the trial court simply repeated the first mistake that was set aside by the circuit court. Devoted is interested in redeeming the property. Its interest is real. It's not theoretical. It redeemed it once. It posted a bond sufficient to redeem the property. It had every intention of doing so. This panel should affirm the circuit court's May 2024 order because that order affords Devoted the right of redemption that it is statutorily given. I'm happy to answer any other questions that you have.
We have no questions. Thank you very much.
Thank you for your time. Enjoy your rest of your call.
Thank you for your patience this afternoon. Rebuttal?
Just briefly, Your Honor, the issue of whether or not the possession judgment was correctly entered, is again, it's already been appealed. It has been appealed. It was appealed to the circuit court. It was appealed to this court. That issue's been decided. The law of the case doctrine says you can't go back in a later judgment, whether it's in the same case or not, and change that decision. And that's really what they're trying to do here. It's also why the court or the circuit court set aside that lis pendens, because it knew that the judgment or the possession issue had been resolved. And that's why this case is moot. There's no possession my client can give back. Unless court has any other questions? All right.
I have no questions.
Thank you very much, Your Honors.
Thank you both.
This matter shall be submitted. All right, turning to item number 24, In re Manzo Hansen minors. We have one person endorsed for oral argument, but nobody has checked in. All right, and with that, this matter shall be submitted. Oh, I didn't call, I'm sorry, oh yeah, I did. In re Manzo Hansen minors. I called it.
Oh, and what about?
I haven't called that yet. I haven't gotten to that yet.
I thought we were leaving.
Oh, no. Calling item number 25, docket number 379090, In re DT Reeves minor. There's no one endorsed for oral argument for today's hearing, so at this time, this matter shall be submitted. And that, I believe, is the remainder of our docket. Thank you very much.
I'm sorry, I'm just.